All right. Good morning, ladies and gentlemen. Let us begin with our state all-purpose calendar.
Good morning, Judge.
Morning. Okay, let's see who's available. Courtroom 2, Ms. Mukeke. Good morning, Mr. Ham as well. Okay. And do we have our PDs in courtroom 2?
Yes, Your Honor, but Mr. McLean is currently talking with one of his clients, and also Paul Bartel. Ms. Vigilante hasn't made it in yet.
Okay. Is Ms. Vigilante there as well?
Ms. Vigilante hasn't made it in yet.
Okay. All right. Do I have any conflict or defense counsel on Zoom who's appearing other than courtroom 2? Okay. Let me begin with a very brief announcement, and then hopefully we'll be able to take one of Mr. McLean's cases by the time I'm done. Good morning, ladies and gentlemen. My name is Judge Lal, and this is the State Court of Fulton County's calendar regarding misdemeanor cases. We call this the State All-Purpose Calendar. These are misdemeanor cases in which individual cases have already been accused, bonds have been set, initial appearances have been completed, and today the defendants who have conferred with their respective counsel will decide how they would like to move forward with their cases. It is essentially a plea and arraignment calendar where the defendants through counsel will let me know whether they would like to plead not guilty and have their cases further noticed for trial, or whether they would like to accept the prosecution's recommendation and enter a plea of guilty or no contest in order to accept a recommended sentence. If you are a defendant who is charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say during the course of this virtual proceeding, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one will be appointed to represent you. Good morning, Mr. Bartel.
Hey, good morning, Your Honor. How are you?
I'm doing good, thank you.
Good.
Are we going to begin with one of your cases?
I believe so. This is Mr. Rhymes, Your Honor. He's number 37 and 38 on the calendar.
My goodness, a big calendar.
Yeah, it's a big calendar.
Yes, it is. Okay. Okay. Tony Rhymes, does that be correct?
That's correct, Your Honor.
All right, Mr. Rhymes, my name is Judge Law. You have been advised of your right to remain silent, and your attorney is Mr. Paul Bartel. How are we proceeding, Mr. Bartel?
Well, Your Honor, I've relayed the state's offer to him. He does have, it looks like the battery is one of the charges, and there's an FTA on another one. So he is declining to enter a plea, or he'll enter a not guilty plea now. And we would like to be heard on bond. It looks like what's holding him in jail is just the FTA. He has a $4,000 bond on that. And I've talked with him. I'm ready to be heard on that if the court is.
All right. Mr. Rhymes, first of all, I've already explained your rights to you. I understand that through your counsel that you intend to enter a not guilty plea. Mr. Bartel, I can arraign the case today, or if you'd like me to read the accusation, or you can waive a reading of the accusation.
We can
Or
wait.
in some cases, defense counsel submits a waiver of arraignment in writing after the calendar. What would you like to do?
We can waive arraignment, Your Honor. He's aware of what he's charged with.
All right. Please understand that my litigation manager this morning is Miss Strong, and Casey Strong, and she will expect a written waiver of arraignment for both cases by the end of the calendar.
Okay, I can do that today, Your Honor.
All right, thank you. All right, Mr. Rhymes, your attorney is entering a not guilty plea on your behalf, and your cases will be further noticed for trial. As indicated, it appears that a bench warrant was issued where you apparently failed to appear in court. And the bond has been set for 4,000. All right, Mr. Bartel, what is the reason I should modify that bond or vacate the bond?
He indicates that he was reporting every week to pretrial on the original bond. He indicates that his pretrial officer did not tell him about the date. He says he didn't receive notice of the court date, so he didn't know about that. He has been in jail for, it looks like 16 days total, 4 days after the arrest, and then he's also been in since May 31st. He was employed, well, he's lost his job now, but he was employed full-time as a delivery driver before his arrest. He does dispute the allegations. He indicates that he was defending his daughter, who is the alleged victim, from an abusive boyfriend of hers. I don't have the benefit of a GCIC. We don't get those, but like I said, he does have ties to the community. His daughter, he has a daughter, 4 grandchildren, and other relatives in the metro Atlanta area. So we would ask for a signature bond on the FTA, or if the court would consider reducing that by half, he still may be able to meet that.
Oh, okay. Ms. Mukeke, do you have, oh, Mr. Ham, I'm not sure who's chiming in. Ms. Mukeke?
Yes, Your Honor.
All right. Any issues with setting aside or reducing the bond?
I think the state would be okay with reducing the bond to $2,000. I would like to point out that based on the warrant, he wasn't defending his daughter. He was actually abusing his daughter, and his daughter did state that he has been abusing her her whole life. And it's his responsibility to be aware of his court dates, to check his mail so that he knows when he has a court date. But we would not be opposed to reducing it to $2,000. We would be opposed to it being a signature bond.
I'm trying to pull up his other case to see what kind of bond did he have. All right, he's already got a court date with Judge Morrison, who issued the original $4,000 bond on June 26th. So he better keep that date, June 26th at 2 p.m. Looks like he missed the court date on February 15th of 2024, hence the bond was issued. He was given a $3,000 signature bond through pretrial on May 8th, 2023. All right, Mr. Rhymes, first big mistake was thinking that your pretrial officer is also your scheduling director. Your pretrial officer has absolutely no duty to let you know when your next court date is. That is your duty. You are not only responsible for making sure when you're supposed to appear in court, you're also responsible for making sure that we have the correct address for you and that the mail is delivered to your home address. If you have issues with the mail or with your address, you are responsible for coming down to the courthouse and making sure that we have the correct address. If your attorneys with the Public Defender's Office, you can always reach out to them to check on your case frequently and to find out when your next court date is. I'm going to reduce your bond to a $2,000 surety bond. But please keep in mind,
I'm sorry.
if you don't want to pay attention to what I'm saying, then I'll be glad to just keep you in jail on the $4,000 bond.
I'm sorry.
As I was saying, your bond is reduced to a $2,000 surety bond. The conditions still apply. No contact with Kaishia Rhymes, and you cannot return to 1890 Plaza Lane. No illegal drugs, no consumption of alcohol, and you're not allowed to own or possess any firearms. Your next court date is already set by Judge Morrison. You are on notice now that the next court date is June 26th in Judge Morrison's courtroom. It appears to be at 2 p.m. If you fail to appear for that court date, she'll simply issue another bench warrant for your arrest. But once you make bond, make sure that we have the correct address. And like I said, you are responsible for keeping up with the court dates, not your pretrial officer. Thank you.
Could I ask a question, Your Honor?
You can ask.
I'm sorry. Did somebody ask me a question?
I wanted to ask, could I go through a bonding company now?
Yes, now you go through a bonding company. It's a $2,000 surety bond.
All right, thank you.
You're no longer a pretrial services client.
Okay,
We can go to position number 42, Mr. Taylor.
Mr. Cornelius Taylor is accused of theft by shoplifting from April 14th, 2024, case 24 CR 2989E. Mr. Taylor, you've been advised of your right to remain silent, and your attorney is Mr. Paul Bartel. With regards to this case, it's going to be a non-negotiated plea. Is that still the status?
That is correct, Your Honor, if the court will hear that.
All right. Mr. Taylor, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Sure.
All right. Ms. Mokeke, yes, ma'am. What is the recommendation for Mr. Taylor?
Yes, Your Honor. The state's recommendation is 12 months probation, serve 100 days, credit for time served 50 days. And that is from April 23rd, 2024 to present. Balance probated, stay away from the Exxon located at 400 Edgewood Avenue, and an anti-theft course. I would like to point out that Mr. Taylor has 88 arrest cycles. He has several theft by shoplifting convictions, 2 from 2005, 1 from 2009, a theft by taking from 2010, a theft by shoplifting from 2013, theft by taking from 2014, theft by shoplifting from 2017, theft by taking from 2018, a theft by shoplifting from 2021, that was NOLO. And then it looks like he has some arrests for theft by shoplifting from 2010, 2019, 2021, another one from 2021, 2020.
Oh, I get the picture, Ms. Mokeke. Thank you. All right. And Mr. Bartel, does your client stipulate to the factual basis, venue, and ID?
He does, Your Honor.
All right. Mr. Taylor, have you consumed any medicine or alcohol?
no, ma'am.
Have you understood the proceedings in your case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Is anyone forcing you to plead guilty today?
No, ma'am.
If you decide to plead guilty, you would have to give up your right to go back to court and have a trial. You will not get the chance to be able to confront your accuser, challenge the evidence that will be presented against you, present your own defenses and arguments, and have the prosecution prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of theft by shoplifting?
Guilty.
Your sentence is going to be 12 months to serve 100 days, credit for time served 50 days. I'm sorry, was this a non-negotiated plea, Mr.
It's
Bartel?
a non-negotiated plea, Your Honor.
I do apologize. I, for some reason, kept thinking it was a negotiated plea, even though I said it out loud. So I'm going to disregard his admission right now, rewind time, and pretend that we are about 3 minutes behind. And Mr. Bartel and Mr. Taylor, I do apologize. I'm not going to accept your plea right now. I completely forgot it was non-negotiated. I'm so sorry. Yes, Mr. Bartel. What
Yes,
what was the defense's request?
Your Honor, the state is correct that he has been in jail for 50 days. He's been in ever since April 23rd. The allegation is that the location was 400 Edgewood, which is an Exxon station. He understands that he cannot go back there, certainly during the pendency of any suspended sentence. We would ask the court to just sentence him to time served, Judge, with 100 days and 2-for-1 credit for the 50 days he's already been in. I believe that would be a fair resolution of the case. And we would just ask the court to give him a 12-month sentence, serve 100 days, credit for time served 50 days, and the balance suspended on the condition that he stay away from this location.
Well, I've already heard Ms. McCarthy give me a rather lengthy criminal history record, especially involving theft of various matters. I don't think, given his multiple, how old is he? My gosh, he's much younger than I am. I don't think he got the message that one cannot steal.
Yes, I do, ma'am. I got the message. Trust me. I do.
No, I don't trust you. Your
Okay.
88 arrest cycles tells me I cannot trust you. I think you need to be on probation, at least for the next few months. I trust that you will not come back to jail.
Well,
So-
Your Honor, we would
I'm
ask,
going to put him on probation to do the anti-theft class. If Mr. Taylor wants us to trust him, then I think he can verify that by taking the class, going to probation, and keeping out of trouble.
Yes, ma'am.
would the court be willing to allow probation to terminate once he does the class?
Non-reporting.
No. Okay.
Yes, ma'am.
He indicated that he will go ahead with this plea with that sentence, Your Honor.
And Mr. Taylor, while you're on, if once you finish the anti-theft class and you are non-reporting probation,
Yes, ma'am.
if you get arrested again, then trust me, we will have you back in jail to serve out the rest of the year. So it just won't be 100 days. It will be the remainder of time you've left on probation. And that you can definitely trust me about.
Yes, ma'am.
So going back to this, does your client still want to move forward with the plea?
Yes, he does, Your Honor.
Okay, so Mr. Taylor, as I've already asked you about whether you've consumed alcohol or drugs and whether you've understood the proceedings, do you understand it still, considering that I have rejected your request for just time served?
Yes, ma'am.
And are you still willing to move forward with this plea?
Yes, ma'am.
And you understand that if you decide to plead guilty, you would have to give up your constitutional right to a trial, go back to court and confront your accuser and have the state prove the charge against you beyond a reasonable doubt. Are you
Yes.
still willing to enter this plea?
Yes, ma'am.
And how do you plead to theft by shoplifting?
Be guilty.
Your sentence is 12 months to serve 100 days, credit for time served 15 days. If you have no other cases holding you at the jail, you report to probation this Thursday. Today is Tuesday, so you'll be at the probation office this Thursday, which will be June 13th.
Your Honor, I know that's on Mitchell Street. Is that 132?
Yes, that will be correct. 132 Mitchell Street in downtown Atlanta. He will report to that office before 3 p.m. this Thursday. And while he's on probation, he has 45 days to enroll in the anti-theft class. Once he has completed the class and provides his certificate, then his probation will be non-reporting. For the first 60 days, I will put him on, his probation fees shall be waived. So the sooner he does the class, the sooner he won't have to report to probation and he will save himself some probation fees.
All right, we appreciate that, Judge.
All
Thank
right, after that's non-reporting. And please keep in mind, if he gets arrested again, we will revoke this probation. Thank you.
you. And thank you, Judge. Thursday.
Next, we can go to position number 41 and 40 through 41, Mr. Robert.
Michael.
Yes, it's-
This is State versus Michael Roberts, case number 22 CR 2769J, accused of criminal trespass from May 5th, 2022. Mr. Roberts also has a bench warrant from May 2nd, 2023, 24 FTA 674. Mr. Roberts, you've been advised of your right to remain silent, and your attorney is Mr. Bartel. Understand this is going to be a negotiated plea. Would that be correct?
That's correct, Your Honor.
Let me just write that down, just give myself alert. Okay.
Yes, you.
And Mr. Roberts, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Ms. McKechnie, this is going to be a time served?
Yes, and then, well, it's 12 months, credit for the time that he served. The balance is suspended. Yes,
Okay.
just looking at my notes.
And to stay away from the truck stop at Donald Lee Hollowell, correct?
That is correct, Your Honor.
All right, thank you. Mr. Bartel, does your client accept these terms?
He does, Your Honor.
And
It
do-
would be, 12 months, served 36 days. I'm sorry,
26.
served 26, yeah, because he served 13 total. So 26 days, credit for time served 13 days. Balance suspended on the condition that you stay away from the Petro at 3181 Donald Lee Hollow.
That, are those the terms to which your clients agree?
Yes, ma'am.
And do you stipulate to the factual basis, venue, and ID?
Yeah, we do.
All right. Mr. Roberts, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings in your cases?
Yes, ma'am.
And is anyone forcing you to take a guilty plea today?
No, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your lawyer to challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. The balance is going to be suspended. You would have, once you are released from this case, you are to stay away from the Petro truck stop at 3181 Donald Lee Hollowell. If you return to that location, you will be arrested, and we get to do this all over again. Understood? Yes, no?
Yes, ma'am. Yes,
All
ma'am.
right, thank you. Your bench warrant is going to be null prost, and that concludes your case.
Thank you, Judge.
Next, we can go to Michael McLean's client, position number 1, Christopher Amos.
All right. We have an interpreter for position 47, Mr. McLean, Mr. Bartel.
Yes, Your Honor, I can speak to Mr. Zuniga.
Do you need a breakout with the interpreter?
Is the interpreter online? Did they hear a person?
I don't see the interpreter online.
Oh, okay. I just saw a chat. The interpreter's okay. As soon as the interpreter is available, we'll put you in a breakout. Mr.
Okay.
McLean, good morning, sir.
Good morning, Your Honor. On Mr. Amos, I have a request.
Yes, sir?
Although it was reset from before, I prepared a package for certain felony attorneys. And it turned out that I kept up with what was going on there, and they switched from one attorney to another. That somebody had made a mistake in assignment. So in addition to the social worker visit being necessary before we can go forward, I really need to talk to that lawyer. I know now who it is, and I've left them a message in 2 different ways, electronically and by a note on their desk. So if we could reset this one more week, I would really appreciate it.
This case is not holding him. Would that be correct? No, it is.
This
He's
is
got a bond. Yeah.
right.
Okay, and the other thing is, if you are familiar with the terms of the plea offer, correct?
Yes, Your Honor.
Okay,
Offers plural. We've got several incidents going on here.
understood. We reset for 1 week to June 18th.
Thank you. Yeah, I'll get with Justin. Mr. Justin. I'll come see you in the jail again. I'll visit you yet again. I don't have a problem.
Next case, please.
We can go to position number 6 through 8, Alto Blocker.
Oh, and by the way, Your Honor, one of my announcements, 4 and 5, had been defendant will decide in the morning. And then
Repeat that again, please.
on 4 and 5, I had sent in an announcement of defendant will decide in the morning.
Yes, sir.
That is a negotiated plea on number 4 and 5.
Okay, thank you.
Thank you.
6 through 8.
Yeah, I mean, Pat's not part of this. We're not gonna be interfering with you.
Mr. Alto Blocker has
Ma'am.
got 3 cases with us this morning. Good morning, sir. Let's begin with position 6. That's 24 CR 2826C, in which he's got 2 counts of criminal trespass and a misdemeanor marijuana charge involving an Exxon at Holcomb Ridge Road. He has a second case, 24 CR 3375C, involving a criminal trespass and possession of a drug-related object at the same incident location. And the third case is 24 CR 3468C, also involving criminal trespass at the same location from December 15th, 2022, criminal trespass. The first case was from June 2023, and the second case was from May 29, 2024. So 2022, 2023, and 2024. I understand this is going to be a negotiated plea. Mr. Blocker, you've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. McLean, Mr. Ham, good morning, sir.
Good morning, Your Honor.
And what is the recommendation for Mr. Blocker?
Yes, Your Honor. Under 24 CR 0028226C, for count 1, criminal trespass, the state's recommendation is 12 months. Balance suspended. 12 months probation, balance suspended. Stay away from the Exxon located at 1105 Holcomb Bridge Road. Count 2, criminal trespass, would merge into count 1, and the state will move to null pros count 3, possession of marijuana less than an ounce.
All right.
For 24 CR 003375C, for count 1, criminal trespass, state's recommendation is 12 months probation, served 4 days. Credit for the time served 2 days, which will be from May 29th, 2024 through May 30th, 2024. Balance suspended. To stay away from the Exxon located at 1105 Holcomb Bridge Road. For count 2, possession and use of drug-related objects, state's recommendation is 12 months concurrent. So the 12 months concurrent with count 1.
All right.
Under case number 24 CR 0036468C. The sole count is criminal trespass. State's recommendation is 12 months probation, balance suspended, to stay away from the Exxon located at 1105 Holcomb Bridge Road.
All right. Thank you, Mr. Ham. Mr. McLean, your client has been in custody now for 14 days. He's got I don't know if the felony matter is holding him, but basically it would be the time that he is served and to stay away from that particular gas station on Holcomb Bridge Road. Are these the terms to which your client is accepting?
Yes, Your Honor. The 12 MP, I think it's a standard hit on a computer key or something. It'd be better to call it 12 MO on these particular fields that are filled in, because each one of these is a time served, balance suspended, including count 2 of case position number 7. So time served, balance suspended in each case, and during the period of suspension, which is the whole year, stay away from 1105 Holcomb Bridge Road. He and I had a heart-to-heart talk about what's going on here. We looked at the dates of each one and the progression, and he has determined that that is over.
Yes, ma'am.
All right, but he
Wait.
understands he won't be released even though he takes his plea. I'm not
Oh,
certain
yes,
the
yes,
bond
Your
is on his Superior Court matter.
Right, he's waiting on a pad placement on that other matter.
Okay,
And, we even talked about the marijuana. He certainly does appreciate the state dropping that case. That's wonderful. And, we talked about the drug-related object and how, that progression has to stop as well.
Mr. Blocker, have you consumed, I'm sorry, Mr. McLean, do you stipulate to the factual basis, venue and ID?
We do.
Mr. Blocker, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's been going on in all three cases?
Sort of, ma'am, but I still have, do I get out? Do I go to the program?
Sort is not really a good enough answer, sir.
No, ma'am, I don't understand. Do I get
Okay.
out?
No,
I won't get out?
no,
you
sir.
You have a
Not,
felony.
not because of the Exxon gas station situation.
It's your felony.
You've got a felony matter.
I thought I would go all on that. I was signature bond.
I'll explain to him what's on the booking screen, or also known as the booking sheet, Your Honor. It says no bond on the felony right now.
That would be correct.
Okay, yes, ma'am.
But that's
Do
not
you
our.
still want to move forward with this plea or,
Yes, ma'am.
all right? So you indicated that you don't understand why you won't be released.
No, ma'am.
So now you do understand?
I don't.
Okay.
But at
Let's
least
see.
you under, at least
I
you
won't
understand.
get that over with, but I don't understand.
All
why.
your problems at the Exxon gas station where you were charged with trespass, those are the only cases I'm dealing with.
Yes, ma'am.
You are also charged with possession of cocaine. I'm not dealing with that at all. That's a separate court and a separate judge.
Yes, ma'am.
So your cocaine charge is going to be dealt separately. Today, we're just dealing with your trespass charges and your marijuana charges.
Yes, ma'am.
So you have a bunch of problems and we're taking them separately.
Yes, ma'am.
So today, I'm only dealing with the trespass and the marijuana. The cocaine charges are going to be dealt by another judge, not by me.
Yes, ma'am.
So if you want to deal with the trespass charges and the marijuana, this is the day to deal with them. Otherwise, we can reset it for a trial.
Yes, ma'am, I deal with rebounds.
So today, we're only dealing with trespass and marijuana. Do you understand those cases?
Yes, ma'am.
And do you understand what we are doing today with the marijuana and the trespass charges?
Yes, ma'am.
Okay, do you need to speak to your attorney any further?
No, ma'am.
Okay. So are you satisfied with the services you've received for just your misdemeanor trespass and marijuana charges?
Yes, ma'am.
And is anyone forcing you to plead guilty to these charges?
No, ma'am.
If you decide to plead guilty, you will not get a chance to go back to court and have a trial in front of a jury. You will not get a chance to sit at counsel's table so that you can confront your accuser, be able to challenge the witnesses and the evidence brought against you, be able to have your attorney present your defenses and arguments. And also, you will not get a chance to have the prosecutor do its job to prove the charges against you beyond a reasonable doubt. You will not get all these opportunities if you decide to plead guilty today. Are you still willing to plead guilty today? Yes or no?
Yes, ma'am.
Are you doing so freely, willingly, and knowingly?
Yes, ma'am.
All right. Let me make sure you understand. On position 6, you were arrested for criminal trespass at the Exxon gas station at Holcomb Bridge Road in June 2023. You were charged with 2 counts of criminal trespass and misdemeanor possession of marijuana. You're only pleading guilty to 1 count of criminal trespass. How do you plead?
Guilty. Guilty.
All right, your sentence is 12 months probation, balance suspended, and you are to stay away from the Exxon at 1105 Holcomb Bridge Road. With regards to the case from May 2024, recently, May 29, 2024, you were charged with criminal trespass and possession of a drug-related object. How do you plead?
Guilty.
On the trespass is 12 months probation to serve 4 days, credit for time served 2 days, balance suspended. Again, you have no additional jail time for this charge, but you cannot return to the Exxon. Count 2, the sentence will be 12 months probation concurrent with count 1. Now from 2022, December 15, again at the same Exxon, you were charged with criminal trespass. How do you plead?
Guilty.
Your sentence is 12 months probation, balance suspended, to stay away from the Exxon at 1105 Holcomb Bridge Road. You cannot be released even though all 3 cases for the trespass are resolved, because you've got your felony case to deal with. Once you resolve that, then you will be released. Do you understand?
Yes, ma'am.
If you go back to that Exxon gas station, you'll be arrested again.
Yes, ma'am.
And we get to do this all over again.
Oh, well, it won't happen again.
It's up to you, sir. It's all up to you. Thank you.
You're welcome.
Thank you. Next case, please.
We can go to position 4 to 5, Mr. Christopher Bennett.
Let's see. Oh.
Mr. McLean, on Jesse Ashford, that's going to be a waiver of arraignment?
Yes.
All right. And so those are going to be further notice for trial? We move on then to positions 4 and 5. Christopher Bennett, who is accused of DUI in possession of an open alcohol container in accusation 23 DF 59088. And this was from a September 30th, 2023 incident. He's got an additional case, 24 DF 2083A, in which he's got one more count of DUI. And we are also addressing that case today. This third case is a bench warrant, and that is 24 FTA 675. A bench warrant apparently occurring on April 3rd, 2024. Mr. Bennett, you've been advised of your right to remain silent, and your attorney is Mr. McLean. We are going to address your 2 cases in which you're accused of DUI in both cases, as well as your bench warrant. Mr. McLean, I understand this is going to be a negotiated plea.
That's correct.
All right, so if the plea moves forward, then the bench warrant will be null pros. Mr. Ham, what's the recommendation for both these cases?
Yes, Your Honor. Under case number 23DF005908A, for count 1, driving under the influence, the state's recommendation is 12 months probation to serve 120 days, credit for the time served, which is 11 days from October 3rd to October 4th, 2023, and then from June 3rd, 2024 until the present day. Balance should be probated. In addition to that, the defendant is required to complete 240 hours of community service, attend Alcoholics Anonymous 2 times a week, sign up and complete a DUI risk reduction class, alcohol drug evaluation and any treatments that's deemed necessary, 2 victim impact classes, 1 year suspension of his driver's license, and $1,000 fine. Count 2, possession of an open alcohol container. State's recommendation is 12 months probation to run concurrent with count 1 and to pay a $265 fine. For the add-on case of 24 DF 002083A, a count of DUI which occurred on July 22nd, 2023, state's recommendation is 12 months probation to serve 90 days, to pay a $600 fine, complete 240 hours of community service, alcohol, drug evaluation, and any treatment that's deemed necessary, a DUI risk reduction class, and that this run concurrent with 23 DF 005908A.
All right. State will now cross position 5.
Yes, Your Honor, and upon pleading to position 4, including the add-on case, the state will move to now cross position 5, 24 FTA 000675.
All right. Mr. McLean, please correct me, but that would mean an additional 47 days, and then after that, he'll be on probation. And I'm sorry, Mr. Ham, the other open case, would that be a concurrent or a consecutive probation?
Concurrent, Your Honor.
Okay, thank you. Mr. McLean, would that be an additional 47 days from today?
It's either 47 or 49. My math might have been off.
I'm counting on you, sir. You're older, wiser, and sager, so.
Mr. Ham, how good are you at math? I was looking at 120 and half is 60, 60 minus
And you're absolutely correct, it's 49 days.
49.
There you go.
The math is math.
All right, Mr. McLean, does your client agree to these terms, and do you stipulate to the factual basis, venue, and ID for all cases?
Yes, Your Honor, for the purposes of the plea, we do. I was also pointing out to him, Your Honor, the 1-year suspension is not something that's administrative anyway.
No, it's actually, this will be his second DUI, yeah, you'll be right.
So, and also he's asking about the possibility of a work permit, limited driving. I don't think that's, if that's
It's not a first conviction, so it's absolutely denied.
right, if that's possible, I'm certainly asking for it, but if it's not available, then,
It's called an affidavit of first conviction, and this is not, does not apply.
Your Honor is correct. Do you
So,
understand?
Mr. Bennett, if you decide to go with this, you'll be reporting to probation every month. You'll be subject to mandatory screenings for alcohol and illegal drugs every month. And you would be prohibited from driving for a minimum of 12 months. Are you in agreement with these terms?
Yes, ma'am.
And Mr. McLean, you've already stipulated the factual basis, venue, and ID. So,
Correct.
Mr. Bennett, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And is anybody forcing you to enter a guilty plea today?
No, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
Have you gone over your waiver of rights with your attorney, and have you understood his explanations?
Yes, ma'am.
Just to repeat, if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court and confront your accuser, challenge the evidence that will be brought against you in a court of law, to be able to present your defense's arguments and mitigating factors with the assistance of counsel, and to be able to have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And pleading guilty to these charges will not only add points to your driving history, it will also result in a mandatory license suspension for a minimum of 12 months. Do you understand, sir?
Yes, ma'am.
Are you still willing to move forward with this plea?
Unfortunately, yes, ma'am.
You need to speak up, sir. I'm losing your audio.
Yes, ma'am.
All right. On the DUI, driving under the influence of alcohol and possession of an open alcohol container from September 30th, 2023, how do you plead?
Guilty.
On the DUI charge from July 22nd, 2023, how do you plead?
Guilty.
With respect to these guilty convictions, on position 4, your sentence is going to be 12 months probation to serve 120 days, credit for time served 11 days. The remainder of the time will be served on probation. So therefore, you have 49 more days, actual days, to serve at the Fulton County Jail before you report to probation. Once you are done with the additional 49 days, you will report to the probation office before 3 p.m. on the first available business day upon being released. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you are on probation, you will complete the following conditions. Your license will be suspended for a minimum of 12 months, and you're not qualified for a limited driving permit, and you're not qualified for a reinstatement for 12 months. You are to complete 240 hours of community service, and you will complete a minimum of 40 hours per month. That means 40 hours of community service per month must be completed every month when you report to probation. As soon as you're released from Fulton County Jail, you will take immediate steps to enroll in a qualified AA Alcoholic Anonymous program, and you shall do so within 30 days of being released. Once you are enrolled in a qualified AA program, you will attend 2 AA meetings per week. You will complete a risk reduction program, and that must be completed within 45 days of being released. Also, within 45 days of being released, you will submit to an alcohol and drug evaluation and submit yourself to any kind of alcohol or substance abuse treatment that's required. You will attend and complete 2 victim impact panels, and you will pay a fine of $1,000 for the DUI and $265 for the open alcohol container. You will make a minimum payment of $100 per month towards your fines, and $100 every month thereafter. For the additional case 24 DF 2083A, there will be an additional $600 fine, and the other requirements of community service, ADET, DUI risk reduction will be concurrent to the first case. Your bench warrant will be null prost. You will be subject to mandatory screenings every month that you report to probation for alcohol and illegal drug substances. If you fail a screen, or if you don't complete these requirements in a timely manner, your probation will be revoked and you will complete the rest of your sentence at the Fulton County Jail. Thank you. That concludes Mr. Bennett's sentence.
Okay. Thank you.
Next is gonna be position 16 and 17, Terrell Gas.
Ms. Vigilante, good morning.
Morning, Your Honor.
How are you?
Good, how are you?
Doing well, thank you. All right. Have you had your conversation with Mr. Gaskin?
Yes, Your Honor. Mr. Gaskin would like to enter a negotiated plea this morning.
All right. Mr. Gaskin, you've been advised of your right to remain silent, and your attorney is Ms. Vigilante. And may I place you under oath for purposes of the plea? Mr. Gaskin, can you hear me, sir?
I can hear you.
Good. Could
Got
you
it.
please raise your right hand so I may place you under oath for purposes of the plea?
He is raising them, Your Honor, but there you go.
Okay, why don't you sit back so I can see you as well? Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I solemnly swear and affirm.
Thank you. You may put your hand down. Mr. Ham, what's the recommendation for Mr. Gaskin?
Yes, Your Honor, under 23 CR 007166J, Soul County loitering and prowling. State's recommendation is 12 months served, 24 days. Credit for the time he's already served, which is 12 days from November 19th, 2023 until November 21st, 2023, and from June 3rd, 2024 until present. The balance to be suspended. To stay away from Aventine, AVENTINE, at Lindbergh, located at 740 Sidney Marcus Boulevard.
And the state will null pros the bench warrant?
Yes, Your Honor, I keep forgetting
Thank
that part. And the state
That's
will
okay.
null pros 24 FTA 000676.
Thank you. Ms. Vigiletti, does your client agree to these terms and do you stipulate to the factual basis, venue and ID for this charge?
We do, Your Honor, and those are the terms we discussed. I've provided Mr. Gaskin that address. He knows he has to stay away for the next 12 months and this will be closed.
All right. Mr. Gaskin, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your legal services?
I am.
If you decide to accept this recommendation and plead guilty to loitering or prowling, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be. Okay. Did you say you do agree?
Yes, Your Honor.
All right. I just want to reiterate that I'm sure your attorney has gone over this with you, but that means that you will not get the chance to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Prepared.
Repeat.
I am prepared.
How do you plead to one count of loitering or prowling on November 19th, 2023?
Guilty.
Your sentence is 12 months to serve 24 days, credit for time served 12 days. If you have no other holds at the Fulton County Jail, then you will be released within 24 hours. The remainder of your time is suspended, but you are required to stay away from this location called Aventine at Lindbergh, located at 740 Sidney Marcus Boulevard in Atlanta, Georgia. If you return to that location, you will be arrested. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. The bench warrant is null crossed.
Your Honor, we can go to position 43. Mr. Bill.
All right.
I apologize. What number are we on?
43, Dolores Veal. Would that be correct, Mr. Bartel?
Yes, Your Honor, that's correct.
All right, and his case number is 24 CR 3298F. Charges driving while license suspended revoked, DUI under the influence of alcohol, less safe, 2 counts of striking an attendant vehicle, and 1 count of misdemeanor possession of marijuana. Mr. Wheel, you've been advised of your right to remain silent, and your attorney is Mr. Bartel. And I understand, is this still going to be a not guilty plea?
It is a not guilty plea. That's correct, Your Honor. We would ask to be heard on bond.
All right. And would you be filing a waiver of arraignment, Mr. Bartel?
Yes, we will, Judge.
All right. Mr. Veal, your attorney will be filing a waiver of arraignment and entering a not guilty plea on your behalf. Meanwhile, we will address your bond situation. And Mr. Bartel, let's see now, how long has he been in custody?
It's been in custody for 15 days, Your Honor, since May 28th. And this is a fairly complicated case. It involves allegation of DUI, alcohol, less safe, allegedly struck 2 vehicles and was driving on a suspended license. I have pretty much no discovery on this case. I have the accusations. There's a copy of the warrant, but the warrant doesn't address the issues of really any investigation of the DUI less safe, or what the circumstances were, or what the evidence is that its license was suspended. There was body worn camera video, but of course, we have not had a chance to get that or look at it. My client indicates that the reason he drove away from the scene was that the alleged victims actually had guns that were pointed at him, and he was in fear of his life. He indicates that the officer took those guns, but there's nothing about that in the warrant that I have. So again, in order to properly represent this case and advise him about entering a plea or going to trial, we would need more time. So that's why we're entering a not guilty plea, and we're asking for a reduction in bond. I don't have the benefit of having his GCIC, but right now he's got a, it looks like $3,500 total bond. If the court will consider reducing that to 2,000, we would ask the court to consider doing that. He indicates that he lives at 2001 Sylvan Road. That's Atlanta, Georgia. He was working for Hydrospec. That's a fence and erosion company. So he's been employed. He has family in the metro Atlanta area, including his mother, his wife, 3 sisters, and an aunt and an uncle. So he's got ties to the community. So given all that, again, we're entering a not guilty plea, and we would ask the court to consider a reduction in bond.
He's got a Clayton County hold as well. So that much I do know, but Miss.
I believe that's a traffic ticket, Judge, is what he said.
Is it? Okay, I don't know. It's got a no bond status and it says Clayton County, so I have absolutely no idea, but I think I can get some information. My pretrial officer, Miss Tyson, good morning. Miss Tyson?
Good morning, Your Honor.
All right, we have position 43, Denoris Veal. Could you enlighten us on his criminal history record or driving history, if you have it?
I have his criminal history, Your Honor.
Okay.
Let's see. He has 15 arrest cycles beginning in 2000. He had 1 felony conviction outside the 10-year period from 2009 for willful obstruction of law enforcement officer. He had an FTA from 2011, and within the last 10 years, he does have a FTA from 2016 and 2023, which is his last arrest. He has a felony conviction out of Fulton County for 2 counts of aggravated assault. Disposition date on that case is February of 2019. And it looks like he had an arrest in Henry County, February 2nd of 2023 for driving while license suspended or revoked and no dispositions listed for that case, Your Honor.
Okay.
And I'm not showing any information on the hold, so I'm not sure exactly what that is, what the underlying charge for that warrant is.
Yeah, yeah, so
Let's
the
see.
only reason I mention it also, Mr. Unless Mr. Ham or Miss Mokeke have any.
I'm sorry, Your Honor, it's a probation violation.
Oh,
And that
okay.
warrant was signed March 11th of 2024.
Okay, do you know what's the underlying offense? Do you know if it's felony or misdemeanor?
It looks like it's a misdemeanor.
Okay,
And it may be that what it looks like open on the GCIC, that driving while license suspended, since that's like the most recent thing that doesn't have a disposition listed for Henry County, that may be it.
well, Henry's not Clayton, so.
Oh, okay.
So, okay, let's see now. So that's what we have right now. Miss Mokeke?
Yes, the state's position is that the bond remain at $3,500. He did strike 2 parked vehicles. The warrant does state that the defendant's breath smelled heavy of alcohol and he was unsteady when he was standing. The warrant also states that he called his girlfriend and then attempted to flee in her vehicle while the police were on the scene. So given that, the state's recommendation is that the bond just remain at $3,500, and there was nothing in the warrant stating that any of the alleged victims had guns or that they had guns pointed at him.
Well, again, Your Honor, he does dispute what's involved.
Understood. The bond modification is denied, given the allegations set forth in the warrant. Mr. Bartel, I'm sure the Public Defender's Office will file the appropriate discovery requirements and get everything that's required. Thank you.
Your Honor,
Yes, sir.
Mr. Veal, I've told him what the offer is. He is thinking about accepting that. It puts me in a very difficult position because I can't effectively advise him of the strict sentences of the state's case against him. However, if he wants to proceed with the plea, I think he can do that on a pro se basis.
Okay, I can reset the case to this Thursday. I'm looking at the recommendation. Recommendation requires him to have additional jail time.
That's
It's
correct.
an offer for 90 days to serve 15 days, so even if he decides to accept the plea, he would need to serve additional jail time. So we can reset the case to Thursday to give you and Mr. Beal adequate time to go over the terms of the plea.
Okay, very well, Judge.
Okay,
Thank you, appreciate it.
so this is reset to June 13th. Thank you.
Thank you.
Next, we have position number 24, Mr. Patrick Gordon.
What position?
2-4.
24.
This is State versus Patrick Denmar Horton, accused of simple battery and battery family violence under accusation number 17 CR 2026978Y. Mr. Horton, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is going to be someone in courtroom 2. Mr. McLean, would that be yours? I have Patrick Horton being represented by Miss Vigiletti.
Ms. Vigiletti stepped out to go walk and see a client.
Would she be nearby that she can be called back in?
No, she's I could try to radio the officer. Wait.
Okay. Jail court iPhone, please hold. His attorney has stepped out of the site of courtroom 2. Did you have another case with Mr. McLean or Mr. Bartell?
Well, I have position number 27, Mr. Ethan Hunt.
That's also Miss Vigiletti.
Right.
Well, I have two more. What's your name? I have Mr. Antoine Jones, position number 28.
Vigiletti.
Vigiletti's too. Hold on, I have one more. Mr. White, position number 45.
Okay, that's Paul Bartell. You can go.
That's not great.
You can bring White up.
Okay. Take your hands up. This is position 45, Mr. White.
Thank you.
Yes, ma'am.
Okay. This is State versus Kydrick Rodney White,
Yes, ma'am.
case number 21 CR 0023838A. Mr. White is accused of giving false information to an officer and a misdemeanor offense of carrying a concealed firearm from May 14th, 2021. Mr. White, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is Mr. Paul, excuse me, is it Miss McLeod?
Yes.
Mr. Paul Bartell. Yes, I saw the long note about this particular case from the defense. There is I don't know what has been the outcome of that discussion between the PD and the prosecution. Are we still moving forward with both charges or just one?
We are still considering whether or not to no pros the concealed, carrying concealed weapon, but we're not opposed to a bond reduction.
All right. Mr. Bartell, there doesn't appear to be a decision yet on your counter offer. How would the client like to proceed?
Well, Your Honor, the statute that he's charged under is no longer in effect. That was replaced with another statute that took effect on January 1st, 2023. And the new statute did not have a savings clause, which means that unless there's a savings clause in the new statute, prosecutions under the statute that was voided cannot continue. So Our position is that the state would not be able to prosecute him for that charge. If the state's willing to null pros that, he would be willing to enter a plea on the giving a false name. It looks like he's been in jail. Well, he served 16 days total on this case. And if the state needs more time to consider their position, then we would just ask for a signature bond on both charges. I don't believe it's just that he's held in jail on a charge which cannot be prosecuted.
All right, Ms. Mokeke, could you enlighten me on the bonds that he's currently got?
Yeah, so it looks like he has a $3,500 split bond, a $2,500 SOB pretrial on the giving a false name, and a $1,000 good bond on carrying a concealed weapon. He also has a stay away from Greenbrier Mall, no firearms or weapons. And this was ordered on May 15th, 2021. The state would not be opposed to him having a signature bond.
All right. Mr. White, I'm going to amend the carrying concealed weapon to a $1,000 signature bond through the jail. And on the, by the way, Ms. Tyson, may I have Mr. White's GCIC?
Yes, Your Honor. His, let's see, 3 arrest cycles out of the state of Georgia, beginning in 2021, no felony convictions. His last arrest was in Union City, 2021. And that was for criminal trespass and willful obstruction, both misdemeanors. Disposition on the GCIC just states that the case was bound over July of 2021. He has 1 FTA from this year, and he has 3 arrest cycles out of New York, beginning in 2022. His last arrest in New York was March 19th of 2023. And that was for criminal possession of stolen property in the 3rd degree. Let's see, note on the GCIC just states that the disposition was completed. No other information was provided, Your Honor. Nothing to add.
Thank you.
Mhm.
As I was saying, on the CCW is going to be a $1,000 signature bond through the jail. On the count 1, it's going to remain as a $2,500 signature bond through pretrial services. Please make a note. Level 2, to stay away from Greenbrier Mall, the entire mall, including the parking lot, the sidewalks, and so forth. And he's not to own, possess, or have any firearms on him or near him or in his home or in any car that he occupies. And he's to maintain a current mailing address for the courts at all times.
Very well. Thank you, Your Honor.
Thank you. And by the way, Mr. Bartel, as the bond has been modified, shall I arraign the case today, or will you be filing a waiver of arraignment?
We'll waive arraignment, Your Honor.
All right, please submit a waiver of arraignment for this case, and it's going to be further notice for trial.
Thank you, Judge.
Mhm.
You go to Ms. McLeod's client, position number 23.
Okay.
Excuse me for a moment, is the social worker still in courtroom too? If so, I have dollar for interviewing.
And she's still in here. The social worker.
Yvonne Harris, could you please raise your right hand?
Your Honor,
Okay,
medical,
you may put it down.
Your Honor, medical had a,
Go ahead. I'm sorry, all I heard was medical has, and then you cut off.
a question. Ms. Blunt, did you say that he's ready to be interviewed?
Yes, I was told that he need to talk to the social worker.
And how are we gonna do it? You can use your laptop, Ms. McLean?
Yeah, this is.
You can use your laptop.
Mr. McLean, how shall we facilitate the conversation between medical Zoom panel
Well,
and,
we don't have a phone. The phone works well on Zoom, but we found out that the laptop does not.
I don't have a phone, so that won't work for me.
I have Mr. Paul Bartel's laptop. Would that be available for the social worker to use?
Does your laptop do Zoom?
It does, yeah.
Okay, great. Let's do a Zoom on Mr. Bartel's, because we found out last week mine does not. We know that the ladies do not.
Do we need the records room?
Okay, as soon as the social worker is on, I don't know, I'm so sorry, I can't tell who's in the courtroom too. Who is our social worker, please?
Oh, Mr. Jamal Harris is a social worker today.
All right, as soon as Mr. Bartel's laptop is available on Zoom, medical, we will place you in a breakout. All right, in the meantime, Miss Strong, Miss Grace, you will keep a watch out for Mr. Bartel to be on Zoom?
Yes, ma'am. He's
Okay.
on, but
No, as soon as the social worker is comes on.
okay. And who is the
please,
social worker, Judge?
Jamal Harris.
Gerald Harris, would that be
Okay.
correct?
Yes.
All right,
Thank you.
but he'll be using the Paul Bartel Zoom panel.
Yes, ma'am.
Okay. All right, medical, please hold. We'll place you in a breakout as soon as the social worker comes on Zoom. Going back to Kevon Harris, position 23. Mr. Harris is in courtroom 2. Mr. Harris, you've been advised of your right to remain silent. Your attorney is going to be Ms.
It's me, Your
McLeod.
Honor. Good morning.
Good morning, Ms. McLeod. And your client has got a couple of he's got a possession of a pistol or revolver by someone who's under 18 and misdemeanor possession of marijuana, less than 1 ounce.
Yes, Your Honor. It's going to be a negotiated plea this morning.
All right, thank you. Mr. Harris at Paul Bartel's laptop and deputy at medical, please join the breakout room. Okay. All right, and Mr. Ham, what's the recommendation for Mr. Harris?
Yes, Your Honor, for Mr. Harris, position number 2322 CR 0040020C. State's recommendation for first count possession of a pistol or revolver by a person under the age of 18, first offense. Count 1, state's recommendation is 12 months probation, 12 months served, 210 days, credit for the time served, 20 days, which will be from June 23rd, 2023 until June 28th, 2023. Balance probated, 40 hours of community service, a gun safety course, and no firearms. As it relates to count 2, possession of a marijuana less than an ounce, state will move to null parts of that count.
Ms. McLeod?
Yes, Your Honor. That is our understanding of the terms of plea.
So you understand that your client will be in custody for 85 more days.
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID for count 1?
We do, Your Honor.
All right. Mr. Harris, have you consumed any medicine or alcohol? I do apologize. I didn't think I'd place you under oath. Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Repeat?
Yes.
Okay, you can put your hand down. Again, have you consumed any medicine or alcohol recently? You need to speak up clearly, all right?
No, ma'am.
Okay. And have you understood the proceedings so far regarding your case?
Yeah.
Are you satisfied with your attorney?
Yeah.
Is anyone forcing you to enter a guilty plea today?
Ma'am.
If you decide to plead guilty to count 1, you understand that you have 85 more days to serve at the Fulton County Jail.
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your right to go back to court and have a trial, to confront your accuser, challenge the evidence that will be brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Are you prepared to give up these rights?
No.
How do you plead to one count of possession of a pistol or firearm by a person under the age of 18?
Yes.
Your sentence is 12 months to serve 210 days, credit for time served 20 days. Once you are done with your additional time at the Fulton County Jail, you will then be released, but you must report to probation on the first available weekday at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must do a minimum of 10 hours per month and 10 hours every month thereafter. You will also enroll in a qualified gun safety class, and you must enroll in that class within 45 days of being released. At all times, you are not allowed to possess and own a firearm. You cannot have any firearms on your person, in your home, in any vehicle you occupy, or anywhere near you. Count 2 will be null crossed. Any questions, Ms. McLeod?
No, Your Honor. That is my understanding of the terms of this plea.
No. That concludes your sentence, Mr. Harris. Did you have any questions? All right, thank you.
And Your Honor, that concludes my business before the court today. May I be excused?
Yes, Ms. McLeod, you have a good Tuesday. Thank you.
Thank you. Same to you, Your Honor.
Jail court iPhone. Who do we have, please?
We have, position number 24, Mr. Horton. These are all, Ms.
Ms.
Vigiletti.
Vigiletti. Courtroom 2, is Ms. Vigiletti available now?
No, Your Honor.
Sorry, jail court iPhone. Ms.
Okay.
Vigiletti is not available yet. Fulton County ACDC. Do you have anyone who is represented by Mr. McLean and Mr. Paul Bartel?
Ms. Najee.
Okay, thank you.
Come on, Ms. Najee.
All right. Good morning, ladies at Fulton County ACDC. My name is Judge Law. This is going to be in a plea and arraignment calendar for the misdemeanor cases on our calendar today. You may have a seat, Ms. Najee. This announcement's for everyone there at ACDC. Please remember that you have a right to remain silent. Anything that you choose to discuss in open court today, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Mr. McLean, Ms. Najee, is that, what position number is that on the calendar?
No, that's a probation case in which I need to ask the court to reset that. Her main case, I'm not sure she's even been assigned a lawyer yet, so I need to make sure that we build a fire under somebody to make sure she has a lawyer on her main case. The probation matter, of course, is a no bond, but the main case, I need to find out if I believe she's going to have a bond hearing in a few, around the 23rd, roughly. And so I would ask the court to reset this to right after the 23rd.
The bond hearing is in Superior Court?
Yes, Your Honor.
All right, and you said it's on the 23rd.
I think it's approximately, Ms. Najee, was it the 23rd roughly?
23rd is a Sunday, so thereabouts, like maybe just before or just after?
They told me in 3 weeks, around the 26th.
3 weeks from when though?
3 weeks from when I went to court, which was on the 4th. It's going to be on the 25th or the 26th. That's my next court.
Okay, I'm sorry.
I'm going to reset this case to June 27th. It's a Thursday.
That's perfect.
At 9 a.m. All right. Thank you, Ms. Najee.
Thank you, Your Honor.
All right.
I have another one for Mr. Bartel.
Name, please.
This Madison, position 34. Rosalind Madison.
All right, Ms. Rosalind Madison is position 34. Mr. Bartel, are we ready to proceed?
Yes, Your Honor, we are.
All right. Mr. Bartel, we are addressing two cases involving Rosalind and Chella Madison. The first case is 24 CR 000022J,
Right.
in which she's accused of theft by receiving stolen property and theft by shoplifting. Her second case, 24 CR 2620G. She's got 4 counts of cruelty to animals and 2 counts of tethering. Ms. Madison, you've been advised of your right to remain silent, and your attorney is Mr. Paul Bartel. With regards to Ms. Madison, is this still going to be a non-negotiated plea?
Right, well, she has 2 cases, as the court indicated, the theft by receiving and theft by shoplifting case. We're pretty much accepting the state's offer, but we want to be heard regarding the amount of the fine. That's the only aspect of that that's non-negotiated. Regarding the animal case, Judge, I have the accusations, but I don't have any of the discovery. And since she's already out, apparently is already out on a signature bond on those, that case is not holding her in jail. We'll just ask that that be further noticed. I don't know if she's arraigned, but we can waive arraignment on that second case if the court wants.
All right. So we are moving forward on a non-negotiated plea on 24 CR 22J.
Yes, ma'am, that's correct.
All right, Ms. Madison, for purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes,
You
ma'am.
need to speak
do.
up. Okay.
I do.
All right, gotcha. Thank you. Ms. Mokeke, what is the recommendation for just the 24 CR 22J?
Yes, the recommendation for that charge on count one is going to the theft by receiving is going to run concurrent with count 2. Count 2 is 12 months, served 38 days, credit for time served 19 days, balance probated, a $500 fine, an anti-theft course, and a stay away from Camp Creek Marketplace. It does look like the defendant has 2 prior thefts by shoplifting convictions, one from 2016 and one from 2012, which is why we did include that $500 fine.
Right. And if she pleads guilty to this, this will be her 3rd conviction for theft by shoplifting on her record.
That would be correct.
Okay. Anything else? Are you going to allocate the facts, or is the state going to pause at this time?
We'll stipulate that there's a factual basis for the plea, Judge, and we'll waive venue, or we'll stipulate to venue and jurisdiction for the purpose.
All right, but you said this was non-negotiated with respect to the fine. What is the argument against the fine?
Yes, Your Honor. Well, the recommendation is a $500 fine. Ms. Madison indicated she has some medical issues that she's dealing with that are related to PTSD. And she indicated that she was working. She had a job at a personal care home. She lost that job when she was arrested. She intends to get a job again and start working again when she is out. But obviously she's would have some financial difficulty with that. So we would ask the court to consider that with the fine. We would ask the court to either reduce the fine to, we would ask for either a $200 fine, or if the court wants to convert that to community service in lieu of the fine, we would ask for that consideration.
All right. Mr. Bartel, I do appreciate that situation. I can amend the fine to $250 fine and 25 hours of community service. However, as you are well aware, Ms. Madison will not be released today. She's got a $5,000 bond on a felony theft by receiving stolen property at the present time.
Right.
For
Yes.
a May 28th, 2024 incident. So are you telling me that she's going to be making bond in order to be released? and do probation, or what are we talking about?
Well, anything can happen with that case, Judge. I think it's a fairly non-complex case. And at some point, that case is going to come up and it's a theft by receiving. So I imagine that that would be resolved before 12 months runs out.
She was just arrested about 2 weeks ago. Not even 2 weeks. Yeah, about 2 weeks ago. So I don't understand.
So is the court asking when she's going to be out? I can't answer
Exactly.
the question, Judge. I don't know.
You don't have the answer. Okay.
I don't know, ma'am.
Well, the reason I was perplexed is because you said that the animal control case is not holding her at the jail, but now we have a Superior Court matter that's holding her at the jail.
Well, I was making the announcement on the animal case.
Okay.
To further notice that.
All right. I just want to make sure we're all on the same page. All right. So, Miss Madison, if you decide to move forward with this plea offer for the theft by shoplifting charge, unfortunately, you will not be released from the Fulton County Jail until you resolve your bond in your felony case. Is that your understanding?
Yes, ma'am. May I ask a question?
Well, ask your question and see if it's something that your attorney needs to answer.
If it relates to the bond or the court process, yes.
Yes, I was gonna try to make bond for the theft by receiving stolen property. But I was saying about the cruelty to animal case. What does further notice mean?
Further notice means we're just resetting it to another, you'll have another court date in the future.
Okay, so I can be able to post my bond.
Right, yeah, the animal case is not holding you in jail, but the felony case is.
Okay, so I couldn't get a signature bond on the animal case?
Well, you already do. It's not holding you in jail. You have a signature bond on that case.
Okay, thank you very much.
Okay.
It is an open, active case. You still have to come back to court to deal with that.
Yes, ma'am, I understand.
All right. So, Ms. Madison, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in all your cases so far?
Yes, ma'am.
You understand that you have this case, you have the animal control case, and you have a felony case.
Yes, ma'am.
Okay. And in this misdemeanor case for theft by receiving stolen property and theft by shoplifting, are you satisfied with your legal services you've received so far?
Yes, ma'am.
And is anyone forcing you to enter a guilty plea?
No, ma'am.
And you understand that by pleading guilty to theft by shoplifting, this will be your third shoplifting conviction on your record.
Is it misdemeanor though?
Doesn't matter. It's still a shoplifting conviction. It's still it's a misdemeanor, but still a shoplifting conviction.
And yes, ma'am. Yes, ma'am. I understand.
Well, 3 shoplifting convictions mean that if you ever get arrested for shoplifting again, it will automatically be a felony charge. It doesn't matter whether it's 5 cents or $5,000. That's what 3 shoplifting convictions means on your record.
Yes, ma'am.
Are you still willing to move forward with this case?
Yes, ma'am.
It's been explained to you that if you plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get a chance to go back to court to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of theft by receiving stolen property and 1 count of misdemeanor and 1 count of misdemeanor theft by shoplifting?
I plead guilty.
For count 1, it will be a sentence that's concurrent with count 2, theft by shoplifting. For the theft by shoplifting, your sentence is 12 months to serve 38 days, credit for time served 19 days. Once you are released from the Fulton County Jail, you will immediately report.
So you said I had to serve 38 days?
you serve 38 days, you're given credit for 19 days. In Fulton County, the sheriff gives credit for every day that you served, it is 2 days. So your jail time for this case is over.
Thank you.
However, you will not be released because you still have a $5,000 surety bond on your felony charge. As I was saying, once you make bond and you are released, you will immediately report to the Fulton County Probation Office at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will report every month. You will pay a $250 fine. You will do 25 hours of community service, and the 25 hours of community service must be done at any nonprofit agency that's not a church and not a school, and also not an animal rescue. Do you understand? You have 3 exceptions to your community service. You cannot do it at a church, you cannot do it at a school, and you cannot do it at any animal rescue agency. Understood?
Yes, ma'am.
And
You
Your Honor,
must do.
I'm
Yes,
sorry.
Mr. Bartel.
Yeah, I was just wondering if the court would consider waiving the first 2 months of probation fees in light of.
No, no. Absolutely not. Miss Madison is required to be on probation, and she needs to understand that she needs to pay probation fees. I've already reduced her fine. Okay, as I was saying, she'll be required to report every month. With regards to her $250 fine, she'll need to do a minimum payment of $50 per month and $50 every month thereafter. She is required to also complete an anti-theft class, and she must enroll and complete in the class within 90 days of being released and entering into probation. And at all times, she's to stay away from the entire location known as Camp Creek Marketplace. That includes the parking lots and the sidewalks as well. I've indicated that her count 1 is concurrent with count 2. All right. That completes her sentence. Miss Madison, did you have a question about your sentence?
Upon me paying my fine and doing the class, could my probation be terminated?
Absolutely not. You'll be required to report every month. This is your 3rd shoplifting conviction.
I can't go to gas station no more.
Understood?
Yes, ma'am.
Anything else, Mr. Bartel?
No, that's it, Your Honor.
All right, thank you. And Miss Madison, just to clarify, your animal control case is open, active, and alive and well. Mr. Bartel,
Can I say something, ma'am?
no. Mr. Bartel, you will be submitting a waiver of arraignment, and this case will be further notice for trial.
That's correct, Your Honor.
Now you may say something, Miss Madison.
Ma'am, I love my dogs. I did not tie my dogs.
Don't say anything about that case. No, we're not handling it today.
Yeah, Miss Madison, unfortunately, you have an open animal control case, and I am absolutely certain that you are not allowed to own any animals or have any animals in your household. So unfortunately, that is the bond condition. Understood?
Yes, ma'am.
All right. That concludes your cases. Thank you.
Excuse me, Your Honor. May I do my last 3 females so I can get to Judge Cox's courtroom?
I don't see why not if Miss Vigilante is available. That is our only holdup. Miss Vigilante needs to be available to attend her other 3 clients.
Can I do position number 14, the social worker case?
Okay.
If she's not ready?
That's right.
Miss Vigilante, have a seat. Who's the case in medical? Medical.
Dollar, number 14.
14.
That's Mr. Dollar.
All right. And Mr. McLean, is that your client?
Yes, Your Honor, we're ready to make an announcement.
Go ahead.
I'd like to request a reset. He has a felony case with similar bond or identical bond on that, and I have not yet spoken with the felony attorney.
How far out would you like the reset?
That should be 1 week.
All right, so the case is going to be reset to June 13th. Sorry, not June 13th, June 18th. June 18th at 9 a.m.
Thank you.
All right, thank you, medical. His case is reset to June 18th at 9 a.m.
Thanks.
All right. Ms. Vigilante, you have a couple of folks at ACDC. They've already been advised of their rights. Deputy Milton, who are we addressing first?
Simone Gilmore, position 20 and 21.
Thank you. And Ms.
Yeah,
Vigilante?
I'm sorry, she has a couple up here, Jelco iPhones too. I just
All
don't
right.
want to, I don't want the
Yes.
battery to be dead on the iPhone.
I've got you next in queue, jail court iPhone. Deputy, I'm so sorry. Definitely will be addressing you. 20 and 21 is Miss Simone Gilmore, who's been advised of her right to remain silent and right to counsel. Ms. Gilmore has got a charge of simple battery, family violence, and disorderly conduct under 23 CR 2043F and a bench warrant 24 FTA 677. Miss Vigilante, is this going to be a waiver of arraignment?
Yes, Your Honor, I'm happy to file a waiver, and Ms. Gilmore has a bond request to make this morning.
All right, Ms. Gilmore, your attorney is going to be filing a waiver of arraignment and entering a not guilty plea on your behalf, and both cases will be further notice for trial. Go ahead, and what's her current bond?
She has a $6,000 surety bond associated with missing court on May 7th.
All right, and yes, what's your argument?
Yes, Your Honor, Ms. Gilmore made a bit of a mistake, when this incident first happened, she did move out of her adopted mother's home, and I actually learned that, her adoptive mother, as she's mentioned in the police report, that's actually a colloquial term. She's not her legally adoptive mother, but that's what I'll be calling her because that's how she's referred to in the police report.
Understood.
After this charge, she did move out of her home because of the dispute. And, but since then has still been relying on her adoptive mother to relay her mail. And this court date wasn't relayed along with some important SSI application information. And so Ms. Gilmore and I had a long talk about it being time to update our mailing address, that, you have this dispute with your family and it's time to, not be relying on them for mail any longer. So she does have a stable mailing address. I do have that address. I'm happy to give the court, so I'm not worried about this being an issue in the future. She's happy to continue to comply with no contact with Alexis Morgan. She does have an MH diagnosis and she is looking to get back on some related meds, but she's only 20. She was only 19 when this happened. She doesn't remember what doctor she was diagnosed at. And so I'm happy to, either refer her to Grady or require an eval as part of the bond conditions. That's something she has asked me for. Ms. Gilmore is a long-term Georgia resident. She's faced some terrible, terrible losses in recent years. But when I went and spoke with her yesterday, she was a very positive and highly motivated young lady. She was telling me that in association with this incident, she did get kicked out of her high school, but she's actually already found a new place she wants to enroll to get her GED at a nearby college near to where she's living now, and also just recently got a job offer to be a dishwasher at a hotel. So I do think, because now we have good contact info for her, her time would be better spent kind of working on these projects, getting her feet under her while she awaits a future court date.
We're still waiting on the interpreter.
Okay. Mr. Hamill, Miss Mokeke, I was just waiting for a prosecutor. Do you have any objection to a signature bond? She was originally granted one about a year ago. No contact with Alexis Morgan to stay away. So that's the current status we have.
Yes, Your Honor, the state would object to a signature bond since she's been released on this particular case. She picked up another fray case out of Decatur Police, as well as a criminal trespass out in DeKalb County. Though that charge stems from an incident that happened on November, excuse me, she was already out on bond on November 13, 2023 on that case. That case is still open out of DeKalb County. So based upon that, Your Honor, the fact that she was already out on bond, the state is objecting to a signature bond in this particular case.
All right. The $6,000 surety bond is going to be amended to a $6,000 signature bond through pretrial services, level 1. No contact with Alexis Morgan. Stay away from 5495 Twin Lakes Drive in South Fulton. No alcohol, no drugs, no firearms. And she must maintain a current address with the clerk's office at all times.
Thank you, Your Honor. I'll get that address updated today.
All right.
Judge, what's your breakdown on each charge? Is it 3 and 3?
Well, it's a.
Or are you doing it on the bench?
On the bench warrant, on the bench.
bench warrant, okay.
Right. She's already got a signature bond. I'm just gonna reinstate her bond for the other case.
Your Honor, can we
Miss
go-
Miss Gilmore, if you don't keep up with your court dates, they're going to just issue another bench warrant for your arrest. And with these repeated failures to appear, the likelihood of being released the next time is very small.
Yes, ma'am.
All right. Thank you.
I got
I apologize. Was it through the jail or
It's
pretrial?
no, pretrial level 1.
Thank you.
Miss Gilmore, I'm coming by to see you this afternoon, so to give you some contact information for your public defender going forward, so you can ask me questions then, okay?
Okay, I just had a quick question for the judge.
Yes.
Am I gonna be able to get, are y'all giving me a signature bond? Or is it-
Yes.
Okay, thank you, Judge, and I promise to come to my next court dates and
Okay.
update my phone number and everything.
Thank you.
Your Honor, can we go to jail iPhone?
Oh. Who do we have?
We have position number 24, Mr. Horton.
Miss Vigilante, this is your client, Patrick Horton, accused of simple battery and battery family violence from December 4th, 2017, case 176 CR 26978Y. With regards to Mr. Horton, do you still need to speak with him?
Your Honor, I have a bit of a conundrum with Mr. Horton. This case was sealed at one point, so I do not have access to documents. He is telling me the complaining witness is an employee of a residential facility, so that would not be a battery family violence situation. And so I really do need some more information. And in the absence of more information, I'd like to make a bond request this morning.
All right. Will you be filing a waiver of arraignment?
Yes, Your Honor.
All right, Mr. Horton, your attorney will be entering a not guilty plea on your behalf, and the case is going to be further noticed for trial. Yes, go ahead.
Yes, Your Honor. So, this is a 2017 case. It is very old. And it appears that Mr. Horton was actually listed as a missing person out of Rockdale by his family. He does have some MH diagnoses, and at one point this case was sealed. And so because I don't have any documentation, of course, we can't enter a plea this morning with no information when this was possibly not accurately charged. Mr. Horton did provide a Rockdale address. So we do have a mailing address. He did also provide me a phone number. And so I do think, especially given that the state's plea offer was time served on the jail portion, it seems that we're all in agreement that there's no risk for Mr. Horton being out of custody. We do have contact information, and I do, like I said, think we desperately need more information here to sort out what happened and whether these charges are accurate and appropriate. So I'm requesting a signature bond today to give us a chance to get that information.
Mr. Ham?
Yes, Your Honor, based upon this record, the state is not opposed to a signature in this particular case.
All right.
But we've been in contact with the victim in this case. And we can confirm that she is not an employee and this is appropriately charged.
The bond on the simple battery is 500, on the battery family violence is 1,000, 1,500 signature bond through the jail. No contact with Celestine Bryant.
Thank you, Your Honor.
And this is going to be a waiver arraignment and further notice for trial. All right. May I go to ACDC for the next case?
Your Honor, can we try to do the two cases that's Ms. Vigiletti's on jail iPhone, because she is on the iPhone and we're trying to do as much.
Okay. Deputy Milton, that is a valid argument. I'm going to address. Thank you.
Your Honor, not a problem. May I be excused to go to first appearance and then I'll come back?
Okay, thank you.
Thank you.
All right, jail court iPhone, who do we have, please?
I'm sorry, position number 27, Mr. Hunt.
All right, we have Jaden Hunt, accused of battery family violence under accusation 24 CR 3163J. And this is from May 20th, 2024. Mr. Hunt, you have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, with regards to this case, this is going to be a waiver of arraignment?
Yes, Your Honor.
All right. Mr. Hunt, your attorney is entering a not guilty plea on your behalf, and the case is going to be further noticed for trial. And what's the argument for bond?
Your Honor, Mr. Hunt, this is, I guess, first I'll just say that this is not really a case that's appropriate for an SAP plea, as these two individuals tell two kind of different version of events. But Mr. Hunt does have significant ties to the community. His sister Jordan has been checking on him. I also spoke with his mom, Jara Hunt, yesterday, you know, who wanted updates on the case and confirmed that he does have a stable address, a friend, and that's an address I'm happy to supply the court. I do have that. I also have his phone number. I called the number.
Ms. Vigiletti, before you move on, he's got a signature bond through pretrial level 2. What exactly are we disputing?
My understanding is that Mr. Hunt's bond was a surety bond. If he has a signature bond, then I'm not sure what would be holding him in the jail.
He had a bond surrender from pretrial on May 30th. So, gosh, something happened in 7 days. Ms. Tyson, do we have an issue? With
Let me check. I believe he had a felony case. He was on pretrial supervision. Give me 1 second. Let me open it back up again. Because it looks like he was in good standing with this 24 CR case.
Looks like the bonds have been added into the jail incorrectly. He's got a UJR with the felony matter, and he's got, unless, of course, I mean, pretrial, tell me what happened, because the jailing indicates it's it says surety bond, pretrial release.
I believe it's because this 24 CR was a new arrest. Let's see.
Mayor, Your Honor, I believe he picked up a new case.
Yeah, he picked up a new case. He picked up a new case, Your Honor.
And what's the date of the new case?
The May 20th, 2024.
Your Honor, this is the new case.
Yeah, this is the new case. So he has a 20, it's like a 23. Let me get it's a 23
okay.
CP case, and then he got arrested with this battery family violence charge.
Is it the same charge? It looks. He's got a battery family violence from May 21st, and then he got booked in on May 30th on another battery family violence. Does he have a new?
And a VGCSA.
Your Honor, it appears that he was given a signature bond on May 20th on this case. And then the bond surrender is entered May 30th, which is when an accusation was entered of possession of methamphetamine. But I do believe that's one incident because I believe the drugs were on his person when he was arrested, allegedly. But I do believe that is one offense date, so I'm not sure why on the 30th there would be a surrender of that signature bond.
And I don't see any notes in here saying that the bond was surrendered in
It
here.
just says that in jailing, so,
Yeah, it just says it in the jailing, but not
okay, all right.
under his notes for
Um,
pretrial.
Understood. The pretrial bond surrender in this particular case, 3163J is going to be amended back to a signature bond through pretrial services, level 3.
The new.
All right. He's going to be subject to mandatory, or random screen, excuse me, for alcohol and illegal drugs. And the same conditions apply. Stay away from the travel lodge, no contact with the victim. So I'm just raising the level of pretrial supervision. So no contact with Kiani Green. Stay away from the travel lodge at Old National Highway. And he can return one time to the travel lodge with a police officer to retrieve his personal belongings if they're still there.
Thank you, Your Honor.
Mr. Hunt, well, if you get arrested again, if you consume illegal drugs, if you have illegal drugs on your person, or if you violate any of the conditions of your bond, like you don't report to pretrial once a week, or you consume alcohol, or you're in possession of firearm, any of these, please remember, please remember, when you come back to jail, bring $5,000 with you.
Yes, ma'am.
All right, thank you.
Thank you.
And Your Honor, the Spanish interpreter is on, so when Mr. Bartel comes on in the breakout room.
Yes, let me, Miss Bartel is, excuse me, Miss Vigiletti, is Mr. Bartel available to speak with his client? And I don't know where his client is.
Yes, they're together, Your Honor. So they're just getting logged in and they'll be in the same room together.
All right, Miss Chansey, good morning.
Good morning.
All right, Miss Grace, as soon as you see Mr. Bartel with his client, there they are. Please, Miss Chansey,
we're here,
we're going to
Judge.
place you in a breakout room with Mr. Paul Bartel.
Yes,
And
ma'am.
Miss Kiani Green, please unmute and start your video.
Yes, ma'am.
All right. Are you Miss Green? Are you Miss Green? All right, Miss Green, we cannot hear you. Miss Kiani?
Yes, ma'am.
Are you lying down in bed?
I am.
Get out of bed. Put down your hoodie.
I'm on.
This is not how you appear in court. Can't hear you. Cannot hear you.
Can you hear me now?
Cannot hear you, cannot see you.
Can you hear me?
Cannot see you. You need to be in a room either with the light shining on you.
I'm on bed rest. That's why I'm in the bed currently.
sit up and put that hoodie away from your head. This is not how you appear in court. Okay.
I'm sorry. I'm on
Raise
bed
your right
rest,
hand.
so
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
What would you like to tell me about Jaden Hunt?
With that no contact order, that would stop him from coming to our appointments for our child. I am currently 2 months pregnant, so.
Are you married?
I was.
Okay,
No.
so he is required to stay 200 yards away from you and he cannot have any contact with you. And if he wants to have contact with the child, he will need to file a legitimation action so that he can see the child once it is born.
All right, I was told that there was 2 type of stayaways. It was a non-violence order or something like that.
Understood, but I've got him on a no further contact.
All right.
All right. Anything else, Ms. Green?
That's all.
All right, you can go back to rest. Thank you. You're free to go. Okay, who am I addressing next?
We have position number 28, Mr. Jones.
All right. I have all these individuals who appeared. iPhone 6, Jamie Rubinsky and Veronica Eagle. Please stop your video and mute your screen until you hear the defendant whose case you want to address. All right? So stop your video and mute your screen until you hear the defendant. Jail court iPhone, we have position 48. And who is the counsel for that case?
I am, Your Honor.
All right, is this 48?
I'm sorry, this is position 28.
28, so okay. Okay.
If I may, Judge, just speak very briefly with Mr. Jones. I did speak with Deputy Falk yesterday, so I have a slight update to the recommendation I'd like to relay to him.
I can reset him to June 13th and you can talk to him then, because I really need to move on.
Okay, we are alone in the courtroom. It would be literally 60 seconds just to update him on one piece of the plea offer.
Okay, go ahead and put courtroom 2 and jail court iPhone in a breakout, Miss Grace. Medical, who do we have, please?
Yes, ma'am.
This is position number 39, Robertson.
Please tell me it's Mr. McLean's client. Oh, it's conflict. Ronald Roberson?
Yes.
All right, Ronald Roberson's represented by conflict counsel. Mr. Roberson, who's your attorney? At medical, who is your attorney?
I forgot his name, Your Honor.
Is it Dennis Murphy?
I'm not sure, ma'am.
Okay. Do I have conflict counsel on Zoom? I don't have your attorney present here. So it's very important that I know who it is so we can contact this person. Miss Mokeke, have you dealt with defense counsel? To whom did you send the offer?
Deputy Fox sent out the offers. Let me double check and see who she sent them to. But I have not had contact with defense counsel.
Position 30. Are you Mr. Roberson? Okay.
Yes, it's 39.
I'm just trying to find out. I don't have an entry of appearance. Are you certain you spoke to an attorney on May 28th when you were in court?
I had an attorney when I went to court yesterday. I mean, preliminary hearing. I spoke with him on the phone.
And you don't know the name. Okay. I'm going to reset your case to this Thursday. Today is Tuesday. And I'm going to reset it to this Thursday, June 13th.
Yes, ma'am.
We need to identify who your attorney is so that your attorney will be present to address your case. I don't have your attorney. No idea who it is. And hopefully
Ma'am?
we'll be able to, I said, no idea who it is.
No, ma'am.
And we need to track this person down and have them available to speak with you on
Yes, ma'am.
Tuesday. Thank you.
Thank you.
Medical, Mr. Robeson's case, Miss Grace. Either we
Yep.
contact Mr. Dennis Murphy and
I-
see if he is.
I gotta do it.
Okay,
I mean, I'm taking care of it. I'm sorry.
I appreciate it, Ms. Strong. We need to contact him and see if Robeson's his client and have him address it on this Thursday. All right? Miss Vigiletti?
Honor, oh, I'm sorry. Yes, Your Honor, Mr. Jones would like to discuss the possibility of a non-negotiated plea this morning.
Okay. This is Antoine Jones, correct?
Yes, Your
All right, so his case is 24 CR 3438F, position 28 on the calendar, accused of stalking. He's got another case, 24 CR 1237F, accused of willful obstruction of an officer and fare evasion. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. This is going to be a non-negotiated plea hearing, which means that the state is going to give me one recommendation for both your cases, and then your attorney is going to argue for an alternative recommendation. I will make a decision as to which recommendation I will consider, let you know, and then you can decide whether you want to move forward with your plea or whether you'd like to plead not guilty and further notice your case for trial. Ms. Mokeke, what's the recommendation for Mr. Jones?
The recommendation for Mr. Jones on his stalking charge is 12 months, serve 120 days, credit for time served 49 days, and that is from April 24th, 2024 to present. No further contact with the victim, Tamia Allen, stay away from the victim's residence, and no firearms. The defendant did repeatedly knock on Miss Allen's door. She called the police several times, but he continued to come to her residence. He shattered her sliding glass door, which he got a criminal trespass for. He's called her nonstop while the police were there. He called her at least 6 times while the police were interviewing her. And the defendant has had to remove items from her porch and her backyard because she's afraid that he's going to come back and try to break into her house. He does have a 2021 simple battery arrest that was no prost, as well as a 2015 family offense, domestic violence, simple assault in Alabama, and a 2021 battery conviction. For his add-on, 24 CR 001237F, for count 1, fare evasion, it is 12 months, serve 8 days, credit for time served 4 days, balance probated, stay away from all MARTA locations, and this is going to run concurrent with 24 CR 003438F. For count 2, the willful obstruction, that is 12 months concurrent with count 1 and a $300 fine.
All right, Ms. Vigiletti?
Yes, Your Honor. When I spoke with Mr. Jones yesterday, he took full responsibility for this incident. They were in the process of a breakup at this time, and he made some poor choices, and that's exactly what he told me. He was 100% clear. He will not be contacting Miss Allen's again, will not be going to her house again, you know, happy to comply with the stay away and all conditions of probation. His primary concern was, 11 more days in the jail because he is working at Cleveland Electric. It is a union job, and he is supposed to be starting an apprenticeship to be certified as an electrician. And so, of course, it's already been quite difficult, and it's very likely a testimony to how valuable he is that he's been able to retain the job this far. And, because he has really accepted responsibility for what happened in the last 49 days. I am asking, Your Honor, for time served on the jail portion of this today so that he can get back to work, get focused on the things that are, productive in his life. In addition, Your Honor, it does seem the only requirement of probation is to pay the $300 fine related to the willful obstruction. Of course, stay away from Ms. Allens and stay away from Marta. And so we did also want to ask Your Honor if you'd be willing to consider allowing probation to go to a non-reporting status upon payment of the fine. Like I said, this was a bad breakup for which he takes full responsibility, made some bad mistakes, and we're very clear on no further incidents with Ms. Allens. I do have a stable address that I'm happy to provide the court as well.
Tamia Allen, are you on Zoom? If you're on Zoom, this would be a good time or Ms. Mokeki, has the prosecution reached out to the alleged victim to confer with her with regards to this alternative recommendation that the defense is indicating?
No, I do not believe our office has had an opportunity to reach out and speak with her. I would also our biggest concern here is the victim's safety. It's not like he called her a couple of times and then left her alone. This was repeated. He repeatedly came to her house. He broke her back door to try to get into the house. He keeps texting her, is anyone in the house? She's had to, change her life around. She's terrified. So our recommendation stays the same.
I'm not going to accept the plea offer by either the state or the defense until I am persuaded that the alleged victim has been consulted about this recommendation. Both of them. Both the state's recommendation as well as the defense's recommendation of no additional jail time. So I can reset the case, or Ms. Vigilante, if your client wants to enter a not guilty plea and further notice the case for trial. What would you like to do?
Your Honor, because Mr. Jones' priority is leaving jail, if it's possible to reset the case for 1 week, we'd appreciate that.
All right. The case is going to be reset to June 18th. All right. Ms. Mokeki, the state would need to consult with the alleged victim and, if possible, have her appear to make sure that she agrees with either the state's recommendation and or the defense's recommendation. Thank you.
Thank you, Your Honor.
Hey, this is Mike, the plan with Fulton County Public Defender.
Oh, I'm sorry. Yeah, jail code iPhone. Do you have somebody else?
That's all I have on 4 North Africa. 3 more.
All right, so thank you.
In the future,
courtroom 2, did you have anyone to address?
Your Honor, I do have a couple of announcements. I had a couple of cases where, I'm sorry, just very quickly, at medical, is this Lamaya Prather? She doesn't need to be here today. She's been accepted into MH court.
You say that.
What position? I'm sorry, Mr. McLean is, I don't know whether his audio is coming right through Zoom. Sorry. In case he doesn't want us to be part of that conversation. So.
Position 36, Your Honor.
36, okay.
Oh, she's position number 39, Ms. Prather.
Okay, thank you.
I'm sorry. Yeah.
36, Lamaya Prather, and looks like she's been accepted. So how would we like to reset this case?
MH Court has asked us not to reset the case, and Mr. Jordan did send an email that this no longer needs to be on SAP.
All right, so are we entering a waiver of arraignment, letting it move down that course?
I believe that Ms. Melnick already did, but I will.
Judge, we don't need one.
Okay, all right. So I'm just going to further notice this case. Ms. Prather, your attorney will reach out and explain to you what's going on. And I understand that your case is going to take an alternative route. I can't discuss this since it involves personal confidential information. Okay? Thank you. Thank you, medical. Mr. Bartel. Ms. Chansey, yes, what was the client's name, please?
Zuniga, I believe. I don't have the first name and case number, Your Honor.
Last name?
Zuniga.
Zuniga. Okay, got it. Thank you. This is position 47. Our calendar is so big, my stapler is not holding everything together. All right. As soon as Mr. Bartel, we can address Mr. Zuniga as well.
All right.
All right. I have a DV bench warrant matter. Actually, I have three. And I have barely touched any of my probation cases. And Miss Allen's not happy with it. Is there a George Battle III, Spence Brown, and Reginald Lett?
Yes, ma'am.
All right, what's your name?
George Battle.
George Battle III?
Yes, ma'am.
And who's your attorney?
Olivia. Miss Olivia.
Miss Vigiletti? All right.
Yes, Judge.
Miss Grace, let's go ahead and rename iPhone 6 to George Battle III. And Mr. Battle will be addressing you shortly.
George Battle.
Yeah, Battle.
Okay.
He's on a DV bench warrant. Is there a Spence
Yes, ma'am.
Brown? And Mr. Battle, please mute your screen until we get to your case. Spence Bernard Brown. No?
Your Honor, I did email Mr. Brown last week and called him yesterday, and I have not heard back.
All right. Reginald Lett, L-E-T-T.
I did speak with Mr. Lett at length yesterday, so I do believe he'll be here.
All right, thank you. Okay, Mr. Bartel, where's your client, Mr. Zuniga?
He's in the courtroom, y'all.
Let's go ahead and address this case.
Your Honor, he's still filling out the paperwork. He said, can you give him a couple of minutes?
Sure. What paperwork are we filling out, Mr. Bartel?
Plea form. The plea form.
I see. Okay. So we are holding on Mr. Zuniga. Let's address do we have another case to address in courtroom 2? No?
But I can make a couple of announcements on some cases.
Ms. Vigiletti, why don't we address Mr. Battle since he's here right now?
Sure, sounds
Okay.
great.
George Battle, go ahead and unmute and start your video. All right, Mr. George Battle III, case number is 23 CR 76478, in which he's accused of simple assault, family violence, and battery, family violence from December 1st, 2023. Mr. Battle, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel at the present time is Miss Olivia Vigiletti with the Public Defender's Office. This case was accused on December 2nd, 2023, and you were granted a $3,000 good bond on December 2nd, 2023. You apparently had a court date with Judge Roth on May 22nd, 2024. It appears that your notice was returned back, and you had a bench warrant issued on June 4th, 2024 for failure to appear in court on June 2nd. Let's see what's going on. We had a booking address for 703 Forest Lake Drive in Macon, Georgia.
Your Honor, that's his current address.
Okay.
Previously, there was his mother's address in the system.
All right, so he had a 2062 Hart Smith Street in Macon, Georgia.
Yes, Your Honor.
And looks like notice was returned on May 28th. All right. So yeah, so he didn't show up because the address was not correct or not updated.
Your Honor, a couple of different things happened here. He was receiving mail at his mother's house, although he was living with his sister at the 703 Forest address. When his mother moved, she did forward her mail, but of course it doesn't forward mail that's not addressed to her. And so, you know, they believed mail was all being forwarded to the correct place, and it was not in this situation. He did also update his address with the bonding company and made the mistake we hear a lot of folks make of thinking that updating things with the bonding company is updating them with the court. I do know that Cagle Bonding Company is here planning to corroborate Mr. Battle's story, because it's my understanding that he has been checking in with them every 2 weeks. They have a system that I believe is titled Court Dates and Check-ins, where he was getting all of his information. And the bonding company also did not receive notice of the hearing, and so did not let him know. So of course, the conversation we had yesterday was that it's his responsibility to check with the court directly. But given that the check-in system with the bonding company is titled Court Dates and Check-ins, you know, it is an understandable mistake if you know, he believed that that was the best way to find out if he has an upcoming hearing. And I know Ms. Cagle is here if she'd like to kind of speak further about that.
Understood. Thank you. Ms. Tyson, may I have Mr. Battle's GCIC, please?
Yes, Your Honor, one moment.
And while she's doing that, Your Honor, I can just add, I do have a stable address and an email and a phone number for him. He's very responsive the last couple of days, so I don't suspect we'll have another issue. And we did also discuss calling the clerk's office directly every 2 to 3 weeks in the future, just to make sure he has the best information.
All right. What is his current address?
It is the 703 Forest that you see in the system now, so that's already been.
703, just 703.
Yes, Your Honor, 703 Forest.
Okay. Ms. Tyson, if you're ready.
Your defendant has, let's see, 14 arrest cycles out of the state of Georgia beginning in 2010. His last arrest. Last arrest was in Butts County, October 25th, 2023, for possession of Schedule 5 controlled substance and marijuana possession less than 1 ounce. No disposition is listed for that case, Your Honor. Most recent probation violations from 2020 and let's see, 2017. And he has 1 failure to appear from 2012. He has a misdemeanor conviction from 2012, so nothing in the last 10 years. He has 1 cycle out of the state of Florida from 2019, and that was for marijuana, misdemeanor marijuana possession. No disposition listed for that case. He has 2 cycles out of Virginia.
Oh, that's
both
good.
cycles are in 2020.
But the Virginia one was an FTA?
Yes, yes. His last arrest was for failure to appear. That was November 7th of 2020.
Okay, thank you.
You're welcome.
Ms. Mukaki, has the state got any objection to setting aside the bench warrant?
The state does not have an objection to setting aside the bench warrant as long as the bonding company can corroborate what defense counsel has stated.
Ms. Cagle, if you'd like to unmute and raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do, Your Honor.
All right. And has Mr. Battle been consulting with your company to get his court dates and so forth?
Yes, Your Honor. So we do have him on a biweekly check-in, and he does receive court date updates. Unfortunately, Your Honor, we did not even see it on the calendar. So if it was there, and I did go back through them, I we did not receive that calendar.
All right. Let me ask you one thing though. Does the bonding company make a representation to the defendant that they need only consult with the bonding company to get an update on their calendars? I mean, does the bonding company represent to the defendants? You can count on me. I'll be the one to tell you when you need to show up in court.
Oh, no, Your Honor. I mean, we don't lean one way or the other. We do let them know that we will notify them as soon as we are notified. So with state, we get the calendars. With Superior, we get mail. So as soon as we do receive them or we do spot it on the calendar, we do put it in our system, which it sends out notification.
But is the defendant under an impression that the bonding company is to keep them up to date?
No, Your Honor.
Okay, thank you. Mr. Battle, this is not your first rodeo. You've had previous failures to appear, and your attorney is absolutely right. Your bonding company is not your scheduling director. You are responsible for making sure your address is current and that you are the one who keeps up with your notices. All right?
Yes,
I'm
ma'am.
going to set aside the bench warrant. You are going to make sure that we have your correct address with the clerk's office. If you have a correct address with the bonding company, that's great. But your responsibility is to make sure that we have your current address and that you are responsible. If you're going to rely on somebody else to receive your mail, like your mother, you are responsible for making sure you drive to your mother's place and check that mailbox every day.
Yes,
Not
ma'am.
just every couple of weeks, because you get your mail every day. All
Yes,
right?
ma'am.
I'm going to set aside the bench warrant and make sure that you show up in court the next time. Thank you,
Yes,
Ms. Cagle. Thank you. And Mr. Battle,
Thank you, Your Honor. Have a good day.
You
Your
too.
Honor, I do just want to, I'm sorry to interrupt. I do just want to briefly flag that Jamie Rubinsky is the complaining witness in this case, and she is here.
All right. Well, Ms. Rubinsky, did you have something to add? All right. Spence Brown on Spence Bernard Brown. All right, the motion to set aside the bench warrant is denied.
That's for Mr. Brown.
Yeah.
Hello?
Yes, Ms. Rubinsky, please unmute and start your video.
Yes, ma'am.
Reginald Bernard Lett. Reginald Bernard Lett. All right. Ms. Rubinsky, Mr. Battle's bench warrant is set aside. He is still under the terms of a bond order, which means that he needs to, let me just make sure that his bond order is still in effect. This is a bond order from December 2nd, 2023, requiring him to have no contact with Jamie Rubinsky and stay away from the 595 Piedmont Avenue and from the victim's residence. He's not allowed to consume any alcohol and drugs and not allowed to be in possession of any weapons or firearms. Did you have any other comment?
No, ma'am.
All right, you're free to go. Yeah, I'm sorry.
No, I would like to say that that day, it was just a really bad disagreement. It was a real bad disagreement, and I really would like to get the dismissed because nobody was touched. Nobody was.
Okay.
It was just a bad disagreement.
If you can reach out to the prosecutor's victim advocate office, you can speak to Miss Gloria Maldonado.
Okay.
And you can express your wishes there. And then the final decision as to whether to pursue a prosecution is really with the Solicitor General's office of Fulton County.
Okay, so where do I go to get that number? The victims, what is it called?
Miss Maldonado, if you can put a phone number for Miss Rubinsky in the chat and direct it to her, that would be very helpful. Or Miss Mokaki. Miss Rubinsky, please monitor your chat and you should get a phone number where you can reach out to victim advocate.
Okay.
Otherwise, their offices are at 160 Prior Street. Okay, all right. Ms. Rubinsky, you're free to go. Mr. Battle, you're free to go. Moving on to position 3 on the bench warrant calendar, Reginald Lett, L-E-T-T.
Your Honor, if I may call Mr. Lett, I'm very surprised he's not here. He is a single father with multiple children. I want to make sure something's not going wrong here. Maybe he's downtown or something.
Okay. And is Mr. Zuniga ready to address his plea?
We are, Your Honor.
Ms. Chansey, may I place you, do you solemnly swear and affirm the translation you provide will be a true and accurate translation with no changes or embellishments?
I do, Your Honor.
Appreciate it. Thank you. This is State versus Elder Antonio Zuniga, charged with battery and theft by shoplifting.
Este es el caso de Antonio Zuniga con cargos de golpes y lesiones y también ratería de tienda.
This case number is 24 CR 3319F. Instant date is May 28th, 2024.
Oh, it's a Zoom. They sent you a Zoom link. It's a Zoom court. Are you able to do that from your phone?
Oh,
I'm sorry, Ms. Vigiletti, could you please, your audio is interrupting our hearing? Sorry about that.
Este es el caso 24CR3319F con el incidente ocurrido el 28 de mayo del 2024.
This is going to be a plea hearing. Mr. Zuniga, may I place you under oath?
Esta va a ser una audiencia de toma de declaración. Señor Zuniga, por favor, ¿puedo juramentarlo?
Please raise your right hand.
Por favor, levante su mano derecha.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
¿Usted jura solemnemente que la declaración que dará será la verdad, lo mejor que usted pueda hacerlo?
Sí, claro.
Yes, of course.
Ms. McKechnie, what is the offer from the state?
¿Cuál es la sentencia ofrecida por la fiscalía?
The state's plea offer for count 1 is 12 months served 28 days, credit for time served 14 days, 12 weeks anger management, 40 hours community service, no further contact with Kenneth Williams, stay away from all target locations.
One
Was that too fast?
Did you say 10 weeks or 12?
12 weeks anger management.
Thank you. En la sentencia de la fiscalía es la siguiente, son tiempo servido a servir 28 días con 10 días considerados. Después 12 semanas de clases de manejo de la ira, 40 horas a favor de la comunidad de trabajo y una multa de $500 y también un curso para aprender destreza antirrobo.
And on count 2?
For count 2, I apologize. For count 2, that is 12 months concurrent with count 1, a $500 fine, and an anti-theft course.
Para el cargo 2 son 12 semanas también de clases que se cumplen de manera concurrente con el cargo 1, una multa de $500 y para este curso también de antirrobo a seguir.
And just to clarify, these conditions must be completed while on probation, correct?
Yes, that is correct.
Para clarificar, todas estas condiciones deben cumplirse durante el periodo de libertad probatoria, ¿correcto? Sí, es correcto.
Mr. Bartel, does your client accept the terms and do you stipulate to the factual basis, venue, and ID?
We do so stipulate for the purposes of the plea, Your Honor, and he has agreed to those requirements of probation.
Señor Bartel, su cliente acepta todas estas condiciones y usted acuerda con los hechos, la identificación y la autoridad de este tribunal. Sí, y ya lo he conversado todas estas condiciones.
And I do want to state on the record, Your Honor, that I have discussed with Mr. Zuniga any likely immigration consequences of pleading to these charges.
También quiero dejar en el acta que he conversado con mi cliente acerca de las consecuencias que pueden ocurrir al dar una declaración de culpabilidad con respecto al Departamento de Inmigración.
I do believe that he understood our conversation.
Yo creo fehacientemente que él entendió la conversación.
And he has clearly indicated that he does wish to go forward and plead to these charges.
Y él claramente indicó que quiere proceder, seguir adelante con la declaración de culpabilidad ante estos cargos.
And we would ask the court to consider, instead of a 12-month sentence, a sentence of 11 months and 29 days with all of the other requirements being the same.
Y también queremos solicitar a su señoría que se considere darle una sentencia de 11 meses y 29 días, al igual que para los otros requisitos que él tiene en su sentencia.
And I've advised him that that sentence would likely not prevent any immigration consequences, but it may help mitigate them.
Con el entendimiento de que esto quizás no cambie las consecuencias inmigratorias, pero con la opción a que pueda haber una posibilidad que sí ayude.
And I have gone over the plea form with him before he signed it with Ms. Chance.
He repasado con la señora Chancy este formulario y que él subsecuentemente firmó.
All right, Mr. Zuniga, have you consumed any medicine or alcohol?
Señor Zuniga, ¿ha consumido medicamentos o alcohol?
Sí, la verdad, medicamento.
Yes, medication, to tell you the truth.
Are you still able to understand what's going on in your case?
¿Usted puede entender lo que está pasando ahora en su caso?
Sí, la verdad, sí.
Yes, to tell you the truth, I do.
And have you understood what your attorney has explained to you?
¿Y usted entendió lo que su abogado le explicó a usted?
Sí, claro.
Yes, of course I did.
Are you satisfied with your legal services?
¿Está usted satisfecho con los servicios legales del abogado?
Sí, me parece bien.
Yes, I think it's good.
If you decide to enter a guilty plea to these charges, you would have to give up your right to a trial in front of a judge or a jury.
Si usted desea tomar una declaración de culpabilidad, tendrá que renunciar o no usar su derecho a ir a juicio ante un juez o jurado.
You will not go back to court with your lawyer to confront your accuser or challenge the evidence brought against you.
Usted no tendrá que regresar al tribunal a confrontar a los que lo acusan, ni tampoco a presentar ningún tipo de prueba a su favor.
You will not be able to present any defenses, arguments, or mitigating factors.
Usted no podrá presentar ningún tipo de defensa, alegatos o cargos que reduzcan o cualquier tipo de solución para reducir sus cargos.
And you would have to give up the right to have the state prove the charges against you beyond a reasonable doubt.
Ni tampoco podrá usar su derecho de que la fiscalía compruebe su culpabilidad más allá de toda duda.
I will agree to the sentence of 11 months and 29 days.
Voy a acordar a que su sentencia sea de 11 meses y 29 días.
Although the nature of these charges
Pero aunque la naturaleza de estos cargos
can still have a very negative impact upon your ability to get immigration in this country.
Pueden tener un impacto muy negativo con respecto a el permiso inmigratorio para permanecer en este país.
Are you still willing to move forward to plead guilty to these charges?
¿Está usted dispuesto a seguir con este caso y declararse culpable ante estos cargos?
Sí.
Yes.
How do you plead to one count of battery?
¿Cómo se declara ante un cargo de golpes y lesiones?
Bueno, bueno, lo que pasó es ver el video donde salgo.
Well, what happened is on the video where you can see me.
Pero no fue intencionalmente.
¿Se declara culpable o inocente?
Culpable.
Guilty.
How do you plead to one count of theft by shoplifting?
¿Cómo se declara ante un cargo de ratería de tienda?
Culpable.
Guilty.
On the battery charge, your sentence is 11 months and 29 days.
La sentencia por el primer cargo de golpes y lesiones es de 11 meses y 29 días.
To serve 28 days, credit for time served 14 days.
Tiempo para servir de 28 días y crédito por 10 días.
If you have no other cases holding you at the jail, you'll be released within 24 hours.
Si usted no tiene otros cargos que lo estén manteniendo en la cárcel, usted será puesto en libertad en 48 horas.
But you must report to the probation office on Thursday, June 13, before 3 p.m.
Pero tendrá que presentarse el jueves 13 de junio antes de las 3 de la tarde en la oficina de servicios previos al juicio.
While on probation, you will complete 12 anger management classes and do 40 hours of voluntary community service.
Usted va a tener que cumplir con 12 clases mientras esté en probatoria de manejo de la ira y también otorgar 40 horas de trabajo a favor de la comunidad.
You must enroll in the classes within 45 days of being released, and you must begin and complete 5 hours a month of community service.
Y usted tiene 45 días para comenzar sus clases de manejo de la ira y debe usted proveer 5 horas por lo menos de trabajo a favor de la comunidad por mes.
At all times, you must have no contact with Kenneth Williams and stay away from all Target stores.
En todo momento va a tener que usted evitar el contacto con Kenneth Williams y también presentarse ante ningún negocio Target.
On count 2, theft by shoplifting, your sentence is 11 months and 29 days. Also to report to probation on Thursday, June 13th.
And Your Honor, I gave him the address for probation.
Okay.
Por el cargo 2, ratería de tiendas, usted la sentencia es de 11 meses y 29 días y usted tendrá que presentarse ante la Oficina de Libertad Probatoria el jueves 13 de junio. Antes de las 3 de la tarde tiene tiempo. Y su abogado dijo que ya le dio la dirección a dónde ir.
For the shoplifting, your fine is $500 and you must complete an anti-theft class.
Por este cargo de ratería de tiendas, la multa es $500 y usted debe completar una clase para el conocimiento o destreza antirrobo.
You must make a minimum of a $50 payment per month for the fine.
Usted debe hacer un pago mínimo de $50 por mes para pagar la fianza.
And you must enroll in the anti-theft class within 60 days of being released.
Y tiene 60 días a partir del día que esté en libertad para registrarse en el curso de destreza antirrobo.
You report to probation every month until all conditions are completed, and then you continue to report until the 11 months, 29 days are completed.
Usted debe presentarse ante la oficina de registro probatorio una vez al mes hasta que complete todas las condiciones que debe cumplir y también hasta que cumpla los 11 meses y 29 días.
Any questions, Mr. Bartel?
¿Alguna pregunta, señor Bartel?
No, Your Honor.
No, su señoría.
All right. Mr. Zuniga?
Señor Zuniga, ¿tiene alguna pregunta?
No, no, no.
No, no.
Okay. That completes the sentence. Thank you.
Esto completa la sentencia. Gracias. May the interpreter be dismissed, Your Honor?
Yes, thank you very much, Ms. Chansey. You have a good day. Thank you.
You're welcome, you too.
All right. Medical, who do we have, please?
We have position number 9 and 10, Mr. Bryant.
Okay. Mr. McLean, is this still a non-negotiated plea?
Yes, Your Honor.
Okay. We have State versus Miles Terry Bryant, case number 24CR3268E, in which he's accused of 3 counts of cruelty in the 3rd degree and 1 count of battery family violence from May 24th, 2024. His second case is 24CR931E, in which he's accused of simple assault and criminal trespass, causing damage to property from February 27th, 2024. Mr. Bryant, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. Ham, what is the recommendation for Mr. Bryant?
Yes, Your Honor, for Mr. Bryant, position number 9, state's recommendation on 24CR003626, excuse me, 268E, state's recommendation for count 1, cruelty to children in the 3rd degree. It's 12 months probation to run concurrent with count 2. Count 2, battery family violence, state's recommendation is 12 months, serve 90 days, credit for time served 19 days from May 24th, 2024 until present. The balance to be served on probation. For Mr. Bryant to complete 40 hours of community service, a victim impact class, family violence class, no firearms, stay away from 540 Humphrey Street Southwest, complete alcohol and drug evaluation, any treatment necessary, to have no further contact with Dean Smith, unless it's a third-party transfer as it relates to the children involved. For count 3, cruelty to children, state's recommendation is 12 months probation and run concurrent with count 2. Count 4, cruelty to children, the state's recommendation is 12 months probation to run concurrent to count 2. On his second case, 24CR000931E, for count 1, simple assault, state's recommendation is 12 months to serve 44 days. Credit for the time already served, 22 days, which would be from February 27, 2024 until February 29, 2024. And from May 24th, 2024 until present, the balance to be served on probation, to stay away from 540 Humphrey Street Southwest, alcohol, drug evaluation, and any treatment deemed necessary, to have no further contact with Dean Smith, and for this case to run concurrent with 24CR003268E. And for the second count 2, criminal trespass, state's recommendation is 12 months probation to run concurrent with count 1, Your Honor. All right, in this particular case, he's accused of assault and battery against his victim. The victim in this case, the incident was caught not caught on camera, but was witnessed by the children's, the victim's children. Who was 10 years old at the time. State will also bring to this court's attention, he doesn't have any previous convictions. He does have several other cases against this victim in this case. He has a simple battery against her under 17 CR 0215084. Excuse me, 8Y. That case was dismissed. For warrant of prosecution. He also has another case against the same victim, a simple assault, 19 CR 00877Y, which was also dismissed for warrant of prosecution, and another battery family violence, which is 19 CR 00879 which also is against the same exact victim. Although none of these cases resulted in a conviction, the state would like the court to be aware that it is the exact same victim that is currently before this case.
Okay. Miss Tedeline Smith, are you on Zoom?
Your Honor, earlier I spoke to Ms. Smith a few minutes ago on the phone, and she said she didn't want to be on Zoom, but that she would like to be non-violent contact rather, no further violent contact. And I said, well, just if you don't want to be on Zoom, stay by the phone because the prosecutor may want to call you to confirm.
All right. And Mr. McLean, does your client accept the terms, or is this a non-negotiated?
It's not negotiated only in the sense, only on the issue of the extra jail days. He has a proposal to ask the court for.
All right, what's the proposal?
He'd like the court to consider fewer extra jail days all the way down to 0, if possible, for it to be 0. Alcohol is the problem here. I looked at the police report. We had a heart-to-heart talk about what was going on in these incidents and what's been going on for a long time. So if Your Honor can see your way clear to 0 extra jail days, he needs to jump into the ADET is certainly appropriate, but he already knows that he needs the treatment. It's an evaluation to see if you need treatment. If he could get into a very intensive outpatient program and yet have freedom to go to work, he just wants to get back to his work right away and be a provider. But he realizes the seriousness of both fact patterns. We talked about what was going on, what those actions and those words look like to other people, and how that's just can't happen.
Okay. I cannot amend it to no further violent contact unless the victim would like to appear and explain why she believes no violent contact is appropriate, given the rather violent history between him and her. So would your client still like to proceed with that?
Your Honor, could I have a moment to dial her back and tell her that she's going to have to get on Zoom to ask for it if it's going to happen?
And based on her explanation, I will then give you my decision on the jail time.
Sure. Let me just mute for a second. I'll be done.
All right. ACDC, before you move on, Mr. McLean, who is representing the 2 ladies at ACDC?
I've got Ms. Hurst.
I have Ms. Murray.
Your Honor, if it's possible, can we, okay.
I can only address the 2 cases if I know who the attorney is. Is it Ms.
Okay.
Vigiletti?
One is Miss Miss Lindley. No, Miss Lindley is the one that is a conflict. I am. Let's go to Miss Hurst.
Hang on. With regards to Ms. Lindley, who is your attorney?
Your Honor, I requested a conflict attorney for Ms. Lindley, and I do believe Deputy Milton has also tried to call the conflict attorneys. I don't believe we've gotten in touch with one. Ms. Brown, correct me if I'm wrong, but that still needed an attorney assigned.
Position 32 and 33 is reset to June 13, and we'll need a conflict counsel appointed to appear on June 13th at 9 a.m. Ms. Lindley, we'll see you on June 13th. Hopefully with a conflict attorney to speak with you. Next case.
Position
6.
probation revocation 1 and 2.
I'm sorry, Deputy Milton, you were fading out. Was that probation 1 and 2?
Yes, Brittany
Okay.
first.
Okay.
Your Honor, Ms. Hurst is represented by Mr. McLean, who's on the phone. But it is my understanding this is a time served recommendation.
Your Honor, I also have a case at ACBC, Ms. Moon, number 35.
Okay, I was told not to bring her.
Okay. All right, we're waiving arraignment on Ms. Moon.
Okay, we'll
Okay.
further notice that for trial.
I'll get that waiver today.
Okay. Ms. Vigiletti, would you like to stand in for Miss Brittany Hurst?
Sure, Your Honor.
Okay. Ms. Brittany Hurst has got a probation violation matter, 21 CR 7229A, in which she was convicted of one or more of the following charges: 2 counts of theft by deception. She's got a probation violation case, 24 PV 951. Ms. Hurst, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Ms. Vigiletti. Ms. Allen? Yes, ma'am. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Right. What did Ms. Hurst not do, and what's the recommendation?
Your Honor, the defendant failed to complete the shoplifting course as well as pay restitution in an amount of $430.93. At this time, her case has expired, so we asked for her case to be time served.
Ms. Vigiletti, I'm going to report this as a probation violation and commute it to time served. Any objection?
No, Your Honor.
All right. Ms. Hurst, this will be recorded as a probation violation on your record, and it's commuted to time served. Your obligations for these cases are done. Thank you. You should be released unless you have any other holds.
Thank you so much.
Okay. The only one we have left is Dontavis Mitchell. And Deputy Milton, do you have a Dontavis Mitchell? Oh, no, that's a male. So, all right, then I guess we're done with ACDC this morning. Thank you.
Thank you.
All right, Mr. McLean, are we ready to proceed with Mr. Bryan?
The victim in the case has said she was going to Zoom on as soon as she could. She was asking for instructions, and I told her about the join a meeting and put in the numbers and join audio. Veronica Eagle should be on this as well, Your Honor, so I'm trying to dial her to tell her to put her video on.
Veronica Eagle is on, and what is the relevance of Miss Eagle?
She's the emergency contact that was listed, so I called her. I believe she's the number.
All right. I have someone on iPhone with some kind of scarf on her head. If you'd like to unmute and identify yourself. I'm sorry, please unmute.
I'm Celine Smith.
All right, Miss Smith, lower the device so we can see your face. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. I've heard about some interesting alleged violent altercations between you and Mr. Miles Bryant. He is currently considering a plea offer where he would have to serve additional jail time, have no contact with you, and he can see the children through third-party transfer. In other words, a third party must facilitate visitation with the children you share with him. Do you have any comment about this?
No.
All right. Mr. McLean, there is no comment from Ms. Smith. Shall I proceed?
Ms. Smith, did you want the nonviolent contact or no contact whatsoever?
No violent.
Okay, and you understand what that means? Do you understand what that's for?
All right, Ms. Smith. Ms. Smith, please sit up and pay attention.
Yes, I am.
Sit up and pay attention.
No.
I'm about to sentence this individual if he decides to plead guilty. I'm requiring him to have no contact with you, none. He's to stay 200 yards away from you, and he cannot communicate with you in any way, form, or manner. He's also required to serve additional time at the Fulton County Jail before he reports to probation. Do you have a problem with that?
No.
Now, understand, that means he cannot have any contact with you. Do you understand?
Yes.
And you're perfectly happy with that?
Yes.
Do you know what the phrase no violent contact means?
Could you explain?
No violent contact means that he can come near you. He can talk to you. He can be in the same house with you, as long as there's no physical and verbal altercations. Which one do you want? The no contact at all or the no violent contact?
The no contact at all.
All right. Mr. McLean, I think that clarifies the issue. Anything else?
Fair enough, Your Honor. I think she did. So,
Thank you, Ms. Green. I really do. Ms. Smith, I do appreciate you being here. You are free to stay or you're free to leave.
Thank you.
All right. Anything else to add, Mr. McLean?
well, as to the extra jail days, Your Honor, he would like the court to consider that if he could get out, get back to work, if the court can consider 0 extra days or any number between 0 and 26 as low as possible, that would facilitate his being able to provide for his children. And he realizes that he needs to address with an intensive outpatient. He certainly agrees to ADET, but the evaluation is almost superfluous. He's going to outpatient, alcohol, counseling, treatment, whatever it takes.
Okay. Mr. Bryant, alcohol is a symptom. It's not the reason why you behave the way you behave. It's a symptom. And definitely on probation, and I hope in the future that you receive help to address that. My greatest concern is that I've got at least 5 cases with you in Fulton County State Court involving violent altercations with Ms. Smith. That is unacceptable. Absolutely unacceptable. I would have wanted longer jail time, but I'll accept the state's recommendation of 90 days and give you credit for 19 days. Would you still like to move forward with this plea? Otherwise, we can reset your case for trial.
Yes, ma'am.
Which one?
Yes, ma'am. Yes, ma'am.
He's going forward. We had discussed the possibility last night.
Understood.
He's
Okay.
staying with it.
Mr. Bryant, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Have you consumed any, I'm sorry, Mr. McLean, you do stipulate to the factual basis, venue, and ID?
For the purpose of the plea, we certainly do.
Okay. Mr. Bryant, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Is anyone forcing you to plead guilty today?
No, ma'am.
Are you doing so just to able to get out of jail? Are you pleading guilty just so that you could get out of jail?
No, ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court with your lawyer, to confront your accuser, challenge the evidence brought against you, be able to present your arguments, defenses, and mitigating factors, and have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Mr. Bryant, if you decide to plead guilty to battery, family violence, that will go on your criminal history record. Do you understand that?
Yes, ma'am.
That could have an adverse impact on your ability to get a job. And also, if you ever get arrested again for something similar like that, it will automatically be a felony charge. Do you understand?
Yes, ma'am.
Are you still willing to move forward freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to 3 counts of cruelty in the 3rd degree and 1 count of battery, family violence from May 24th, 2024?
Guilty, ma'am.
How do you plead to 1 count of simple assault and criminal trespass causing damage to property from February 27th, 2024?
Guilty.
With regards to position 9, the cruelty to children, the 3 counts, that will be 12 months to be on probation, concurrent with count 2. Count 2 is battery, family violence. The sentence is 12 months to serve 90 days, credit for time served 19 days. you have additional time to serve at the Fulton County Jail, after which you will immediately report to probation at 132 Mitchell Street on the first available business day upon being released from the jail. You will report before 3 p.m. While you're on probation, you will complete 40 hours of community service with any nonprofit agency that's not a church and not a school, and you will complete a minimum of 10 hours per month and 10 hours every month thereafter. You will enroll in a domestic violence intervention program, and you must enroll within 30 days of being released, and you must attend those classes every week with no breaks. You are to stay away from 540 Humphrey Street in Southwest Atlanta. You are not allowed anywhere near that location while you're on probation. You will attend and complete an alcohol and drug evaluation and submit yourself to any treatment that's required, including enrolling with AA. You are to have no contact with Tadaline Smith, which means that you are to stay 200 yards away from Ms. Smith, not communicate with her in any way, form, or manner. You are allowed to see the children that you share with Ms. Smith, but that can only be done through a third party transfer, which means that a third party must be involved in picking up the children and dropping off the children with you. Now, with regards to the visitation and joint custody of the children, I will require you to file a legitimation action with the Superior Court before any visitation takes place with the children. Do you know what that means?
Yes, ma'am.
You must get a court order from Superior Court that says you can see the children this often and with regards to joint visitation. So if there's any visitation, that can be done with a third party. With regards to position number 10, on the simple assault, it will be a concurrent charge. It's 12 months to serve 44 days. Credit for time served 22 days. You'll be on probation, again, to stay away from Humphrey Street. No contact with Ms. Tadaline Smith, and to do the alcohol and drug evaluation concurrent to the other case. The criminal trespass and damaged property will be 12 months concurrent with count 1. That completes your sentence. Thank you. Anyone else in courtroom 2 to address?
Next, we have position number 11, Mr. Cameron.
All right. Mr. McLean, is that your client?
Yes, Your Honor. Cameron's 11, that's a negotiated.
All right. This is State versus Demetrius Cameron, 24 CR 3273F, accused of a criminal trespass on May 25th, 2024 at the Exxon gas station at 151 Cleveland Avenue. He's got a second case, 24 CR 002106F, in which he's accused of criminal trespass at Chevron 221 Cleveland Avenue. Mr. Cameron, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. May I place you under oath for purposes of the plea? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speaker?
Yes.
Thank you. Mr. Ham, what's the recommendation for the 2 cases?
Yes, Your Honor. For 24 CR 003273F, state's recommendation for criminal trespass is 12 months to serve 36 days. Credit for the time he's already served 18 days from May 25th, 2024 until present, the balance suspended. And to stay away from Exxon gas station located at 151 Cleveland Avenue Southwest. For the add-on case 24 CR 002106F, criminal trespass, state's recommendation is 12 months to serve. 12 months community time served. So let me go back and
12 months. I've got 12 months probation concurrent to the other case.
Correct, Your Honor. It's 12 months probation concurrent with 24 CR 003273F, balance suspended, and to stay away from the Chevron located at 221 Cleveland Avenue Southwest.
All right, thank you. Mr. McLean, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
He does, Your Honor, and he does, we do so stipulate.
Mr. Cameron, have you consumed any medicine or alcohol recently?
No, I haven't.
And have you understood what's going on in both your cases?
Yes,
Are you satisfied with your legal services?
yes, I am.
If you decide to plead guilty to these two cases, you would have to give up your constitutional right to a trial. You will not go back to court, not be able to confront your accuser, not have the assistance of counsel to challenge the evidence, present your own defenses, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to criminal trespass with regards to the Exxon gas station?
Yes,
How do you plead to criminal trespass with respect to the Chevron gas station?
yes,
Your sentence for position for case ending in 3273F is 12 months to serve 36 days, credit for time served 18 days. If you have no other cases holding you at the jail, you'll be released within 24 hours. The balance is suspended. You cannot be anywhere near the Exxon gas station at 151 Cleveland Avenue. With regards to the criminal trespass at Chevron, the sentence is 12 months probation concurrent with position 11, balance suspended. Stay away from the Chevron gas station at 221 Cleveland Avenue. If you return to any of these gas stations on Cleveland Avenue, you will be arrested and brought back to jail. Do you understand, sir?
yes, ma'am.
I would require you to stay away from all Cleveland Avenue, but right now, just stay away from all gas stations on Cleveland Avenue. Thank you.
All right.
Next, we have position number 15, Mr. Ferguson.
That,
Is that your client?
that's also a negotiated plea, Your Honor, yes.
This is State versus Eric Ferguson, accused of fair evasion, willful obstruction of an officer, 2 counts, from July 21st, 2022. Case number 22CR4776F. Mr. Ferguson, you've been advised of your right to remain silent. Well, let me just reiterate that. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Hemp?
Yes, Your Honor. State's recommendation under 22 CR 004-776F for count 1, fair evasion. State's recommendation is time served. Count 2, willful obstruction of a law enforcement officer. State's recommendation is 12 months to serve 42 days. He's already served 21 days. The balance to be on probation and to pay a $300 fine. For count 3, willful obstruction of a law enforcement officer, that will merge with count 2, Your Honor. And the state does not upon probation terminate upon payment of his fine.
Okay, thank you. Mr. McLean, we stipulate to the factual basis, venue, and ID.
For the purposes of the plea, we do.
Mr. Ferguson, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Do you know if you currently have a suspension from all model property?
No, I do not, ma'am. It expired.
So you don't know if you have a suspension, or you know for a fact it's expired?
It's expired. From recent time I have served. They gave me like a 90-day restriction.
You're 100% sure that you don't have a suspension?
100% sure, ma'am.
Okay. Mr. Ferguson, if you decide to plead guilty to these 2 charges, you would have to give up your constitutional right to go back to court and have a trial. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to fair evasion?
Guilty.
How do you plead to one count of willful obstruction of an law enforcement officer?
Guilty.
On the fair evasion, your sentence is time served to serve 42 days, credit for time served 21 days. So your jail time is concluded. On the count 3, that will merge into count 2. Count 2, the sentence is 12 months probation to serve 42 days, credit for time served 21 days. If you have no other cases holding you at the jail, you will be released within 24 hours, but you must report to Fulton County Probation on Thursday, June 13th, before 3 p.m. While you're on probation, you must pay a $300 fine. You will report to probation as long as your fine and your probation fees are outstanding. Once your fine and all court costs and probation fees are paid off, then your probation will terminate. You can return to any MARTA property as long as you do not have a suspension. I highly recommend that you contact the MARTA police officers or MARTA police enforcement to verify that you do not have a suspension before you go back on any MARTA property.
Yes, ma'am.
Thank you. That concludes your sentence.
You know,
Can you stand by for our positions 12 and 13? Somebody just went to get them.
Okay, thank you. Mr. Reginald Lett on our bench warrant calendar. Mr. Reginald Lett.
Yes.
This is State versus Reginald Bernard Lett, charged with simple battery family violence from July 24th, 2023. Mr. Lett's case is 23 CR 4585C. And Mr. Lett, please be seated and raise your phone so that it's in front of your face and not staring at your chin. Raise your phone. Raise your device to put it in front of you. Thank you. You can put your hand down. Thank you. Mr. Lett has filed a request to set aside a bench warrant for failure to appear at his jury trial before Judge Dixon on March 14th, 2024. For his current address, I have I want to make sure I recite this address correctly. I have his address listed as 415 Fairburn Road, Southwest, apartment 1709 in Atlanta, Georgia. The notice was sent out on May 17th, 2024, and it indicates that it was not deliverable as addressed. Am I correct? Yes. No, this was a separate notice. I do not know. Maybe it was the bench warrant for failure to appear. But it looks like all his other notices went to him at the correct notice.
Yes, Your Honor, and I believe that the notice that was RTS was to appear in court on June 3rd.
Okay. So anyways, there is a bench warrant and he did not appear for his trial. So, Ms. Vigiletti?
Yes, Your Honor, it's sort of a curious issue. A few months ago, Mr. Lett stopped receiving mail at his address despite not moving at all. He did start receiving mail to his address that had a different person's name on it. He does live in an apartment complex. It could have possibly been a mistaken change of address to the wrong apartment. But a couple of weeks ago, when he realized he wasn't getting his mail, he was getting someone else's mail, he reached out to the post office. They did have him fill out some paperwork, a blue change of address form. Even though he didn't move, he's been at that same address this whole time, just to reestablish receiving mail there. And this, his most recent court hearing was returned to sender, even though he didn't move. He's been in that same place. So Mr. Lett did, of his own volition, go to the clerk's office, realizing, hey, it's been a few months. He had attended a court hearing some months ago where they told him he'd receive a future court date. He knew he had this mail issue. He better go check on this. And in a stroke of bad luck, it was June 4th when he went to the clerk's office and his hearing was on June 3rd. He is a single parent of a 14 and 15-year-old who live with him. He also tells me he's had no contact with Ms. Freeman. There's been no further incident. It sounds like he's reestablished getting mail at his location. I wish I understood what happened there. But you know, the return to sender mail does confirm that there was an issue. I do have a phone number and an email address. He's been very responsive over the last day, so I'm confident we won't have an issue going forward.
All right. Mr. Ham, any objection to setting aside the bench warrant?
I think that's mine.
I'm sorry, Ms. Mulcahy, I'm so sorry. No, go ahead.
The state just doesn't have any objection to setting aside the bench warrant.
Okay, the bench warrant is set aside. Ms. Vigiletti, if you please submit a proposed order. Mr. Lett, first
Yes,
of
ma'am.
all, you are responsible for making sure that you check the mail. If there's a problem with the United States Postal Service, that's something that you have to rectify, not the courts. Second of all, it doesn't bode well that you don't show up at this bench warrant calendar at 11 a.m. when you're required to do so.
Your Honor, I'm so sorry for interrupting. If I may, when I called Mr. Lett, he was in courtroom 4, not courtroom 2. So he had received the wrong Zoom link. My apologies. I should have mentioned that.
All right. So in other words, please make sure that you show up in court on time before Judge Dixon. I will tell you from my experience, Judge Dixon very rarely issues bench warrants. Very rarely. So for her to have done so in your case, you better show up the next time. She will not tolerate any further failures to appear. Thank you.
Thank you, Judge.
Position 12 and 13, Mr. Cope.
This is State versus Marco Cope, accused of criminal trespass. And in case 24 CR 1364G, and 4 misdemeanor offenses under 24 CR 3035G, which include simple battery, theft by shoplifting, simple battery against an officer, and violation of rules regarding pedestrian and roadway. Mr. Cope, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean is your counsel. Mr. McLean, is this still a non-negotiated plea?
The only reason I put non-negotiated, Your Honor, is there's a 2-day difference. I didn't know if it was a typo or if the state thought that 2 days was important. Mr. Ham, could we agree on it being no extra jail days and just do a negotiated plea? It's only a 2-day difference.
He doesn't object to that.
All right, so it will be to serve 56 days, credit for time served 28 days. Would that be correct?
That would do it. Right.
All right.
Thank you.
And so, Mr. Ham, what's the recommendation for positions 12 and 13?
Judge, for position 12, 24 CR 001364G, state's recommendation for criminal trespass is 3 months to serve 3 days, which is basically time served and balance suspended, to stay away from all of Georgia Tech campuses.
And the next case?
For case position 13 on the calendar 24 CR 00303.
Yes, sir.
Count 1, simple battery. State's recommendation is 12 months probation to run concurrent with count 2.
I'm sorry, Mr. Ham. I'm so sorry. You were being interrupted. Could you please repeat again?
It's 12 months probation to run concurrent with count 2 and to have no further contact with Angel Boyd. For count 2, theft by shoplifting, state's recommendation is 12 months to serve 58 days. Credit for the time served 28 days from May 15, 2024 to present. The balance to be served on probation. To stay away from High Society Smoke Shop located at 694 Morsgo, MOROSGO Drive, to take an anti-theft course and to complete 40 hours of community service. For count 3, simple battery against a police officer, State's recommendation is 12 months probation to run concurrent with count 2. For pedestrians in the roadway, state's recommendation is time served.
Mr. McLean, is your client got a valid address?
Well, let's see.
I've got a Memorial Drive, but I don't know if that's a valid address.
I think he might be, I think he may be using shelters at the present time.
Mr. Cope, do you have a valid mailing address or are you residentially challenged?
At the moment, my counselor came to see me from 10 Park Place and said they removed all my belongings out of my room at the Welcome House Memorial Drive now.
So you're not living there anymore?
As of yesterday, excuse me.
All right. Mr. McLean, since we have arranged for the jail time, do you stipulate to the factual basis, venue and ID?
Yes, Your Honor, we do.
All right. Mr. Marco Cope, although you may be residentially challenged at the present time, the sentence requires you to report to probation, to do an anti-theft class, and to have no contact with Angela Boyker and stay away from the high society smoke shop. Will you be able to comply and report to probation?
Absolutely, ma'am.
And you understand that if you fail to report to probation, a warrant can be issued for your arrest and you could be back in jail to serve out the rest of the 1 year.
Absolutely. I'll be there, ma'am.
All right. Mr. Cope, have you consumed any medicine or alcohol?
I took medicine probably when I first got in, but no biopsychosocial. I didn't consume it. Now I have some in my hair, no doubt, but I mean, nevertheless, you know, no actual. Yes, ma'am, I'm guilty.
Are you able to understand what's going on in your two cases?
Not really. That's why I have a 10 Park Place social workers on my behalf, ma'am.
So if you don't understand what's going on in your case, would you need your social worker to be here?
All I know is I love the police and I did nothing to harm them. That's all I know.
Mr. McLean, I can't proceed with this plea if your client does not understand what's going on. I can reset the case to Thursday for him to get a better understanding.
I think that would be wise.
Mr. Cope, Mr. McLean is going to speak with you and perhaps give you further enlightenment about what exactly is going on with your two cases and what exactly would you be pleading to. If you love the police, then you need to understand then what you are charged with. And I'm not going to allow you to agree to something that you don't believe you're guilty of.
Anything this time served, I'll report to the probation. I know I'm capable of doing that.
And I totally agree that you are capable of pleading guilty to get out of jail. But I cannot accept a guilty plea unless you genuinely believe that you committed the alleged offense.
Yes, ma'am. Sure.
See you on June 13th at 9 a.m.
We're at here?
Same place, yeah.
All right, thank you.
All right.
Well, that takes care of the math anyway.
Right. Deputy at courtroom 2, we have one more probation case that we've not reached. Any idea if Mitchell, Dontavius Mitchell?
Right, it's Dontavius Mitchell, and he's a probation case. He's going to be offered time served if we just find him.
So I can reset him to June 13th if we are not going to address him today.
That would be preferable.
Any progress on where in the jail? Is he a trustee?
No.
Oh.
All right. Dontavius Mitchell is reset to June 13th. Miss Allen, we will address that on June 13th, okay?
Okay, thank you, Your Honor. That concludes the business for today.
Yes, thank you. All right, on the probation calendar, position 1 is commuted to time served. Position 3 and 4 are reset to June 13th. And position 5, Roshan Naji, is reset to June 27th at 9 a.m. On the bench warrant calendar, position 1, the bench warrant is set aside. Position 2, the request for a bench warrant is denied. The defendant failed to appear. And position 3, Reginald Lett, the bench warrant is set aside. On the SAP calendar, position 1 is reset to June 18th. Position 2, Jesse Ashford and 2 and 3 is a waiver arraignment and further notice for trial. 4 and is a plea. 5 is null pros. 6 and 7 and 8 are pleas. Position 9 is a plea. Position 10 is a plea. Position 11 is a plea. Position 12 and 13 are reset to June 13th.
I'm sorry,
Position-
I'm sorry,
Yeah.
Judge. Position number 11 wasn't a plea.
Did I miss one?
Position number 11 was Mr.
Yeah,
Cameron.
position 11 is a plea. Position 12 and 13 are reset to June and 13th. Would that, Mr. Marco Cope?
I'm sorry, am I wrong? Because I have Mr. Cameron as a reset for the 13th. Am I wrong? He was a plea?
Cameron was a plea, staying away from Exxon and Chevron.
Okay, I'm sorry. Thank you.
Position 12, Marco Cope, is reset to June 13. Same announcement for position 13. Position 14 is reset to June 18th at 9 a.m. Position 15, Eric Ferguson, is a plea. Position 16 is a plea. 17 is null pros. Position 18 and 19.
Yes, Your Honor, Mr. Gilbert is one of our more spirited clients who the jail staff has a bit of a difficult time with. They did bring me to see him in his cell today. I do understand their concerns. I believe it is possible he was incarcerated at the time he missed court. So I'm going to try to track that down and see if we can get him out of the jail. So if it's possible to reset 1 week for SAP, and if we need to address further, we can at that time.
All right, reset for behavior to June 18th. Position 20 is and 21 are a waiver of arraignment, further notice for trial, and bond has been amended for the bench warrant. Position 22.
Yes, Your Honor, I got lucky this week. I had both of our most spirited clients. Mr. Harden, I am being told, has recently started taking some very necessary medications. So I'd also like to reset that 1 week to see those effects before we make any further decisions.
Reset to June 18th at 9 a.m. Position 23 was a plea. Position 24 is a waiver of arraignment, further notice for trial, and bond has been amended. Position 25, Jenna Hoyt, I believe, has been released. Further notice for trial. That's 25 and 26. Position 27, Jaden Hunt, is a waiver of arraignment and further notice for trial. Position 28 is reset to June 18 for the alleged victim, Tamaya Allen, to be to appear and to be consulted with regards to the alternative recommendations. Position 29, Samira Jones is in currently in the hospital. So what are we doing a waiver of arraignment for 29, 30, and 31? Mr. Bartel?
Yes, Your Honor. I talked with Ms. Jones. I don't know that I can waive arraignment because I was not able to get a response from her in terms of what she wanted to do with her case. But she is able to enter a plea. So I think I would just say further notice it to the trial courtroom and she can be arraigned then.
Oh,
I can arraign her today, or I can arraign her on Thursday, or I can arraign her next week, but I can't further notice it to a trial calendar pending arraignment.
Your Honor, Ms. Jones has been reset 6 weeks in a row because she refuses to speak with us. So Mr. Bartles actually went to Georgia Regional to try to speak with her. She's still refusing here.
Okay. So, we're gonna just reset this case. And that's gonna be to June 18th. I don't know what else to tell you, Mr. Bartel. If she's refusing to work, two of her cases would, this is position 29 would be null crossed. She's got a recommendation for position 30 with restitution. And she's got a probation offer for position 31.
Right, yeah, 29, that, there's a statute of limitations issue. So that should be null pros. But on the other two cases, you know, she is consistent in indicating that she does not want to enter a plea.
Which
So,
case has a statute of limitation issue? Haven't all three been accused?
29. Well, it wouldn't be the first time the case was accused and it was still outside the statute of limitations.
Okay. Mr. Ham, are we going to null pros position 29?
I will look into that and get back to the defense.
Samira Jones.
She may, I mean, she's been at Georgia Regional, I believe, since May 28th, Judge, and appeared to be more stable when I saw her over the weekend. So there's a possibility she'll be leaving there before too long.
Okay. Please be ready with your motion on June 18th on position 29. I'm going to reset all three to June 18th. Thank you.
Oh, just to clear, yes, we will be null crossing position 29.
Excellent.
The battery family violence charges, yes, that will be null crossed.
Okay, position 29, 2 counts of battery family violence and 2 counts of simple battery family violence are null pros. Please submit the null pros order to Ms. Strong. That means we reset position 30 and 31 only to June 18. Position 32 and 33 are reset to June 13th, pending a conflict counsel appointment. So Ms. Grace and Ms. Strong will need conflict counsel to appear on that day. Position 34, that was a plea on the case ending in 24 CR 22J, and the case 24 CR 2620G, that is further notice for trial. Position 35, Deja Moon. I know we're going to do a reset.
We'll waive arraignment on that, Your Honor. It's just further notice for trial.
All right. 36, Lamia Prather is a waiver of arraignment and further notice for trial. Would that be correct?
Your Honor, I don't believe that's needed. She has already been accepted into MH court.
Oh, that's right. Okay, no, that was a different. It's just further notice pending admission to an alternative program. Yeah, okay. Position 37 and 38. This is a waiver arraignment. Bond is amended to $2,000 surety. Position 39, Robertson is reset to June 13th. We need to appoint conflict counsel. Position 40, Michael Roberts was a plea. Position 41 was null cross. Position 42, Taylor was a plea. Position 43, Denoris Veal is reset to June 13th. Position 44, Craig Washington. Are we resetting it to June 13th?
Everybody's in the second row.
I believe that would be a reset, Your Honor. I went to see him yesterday and I'm told he declined to come out of his cell. So Mr. Washington, he's still not.
Okay, We'll reset him to June 18 for position 44. 45 is a Keldrick White is a waiver arraignment and further notice for trial. Bond is amended to a signature bond level 2. And position 46, China Witten. What are we doing?
Ms. Whitten was
She was
released.
released. Yeah.
Okay. Oh, I'm sorry, should have seen it there. And then Zuniga was a plea, position 47. Did I miss any of the cases?
I believe that's it, Your Honor.
All right, we'll be in recess until our C calendar. Thank you, everyone.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
It feels like you've been here all day.
We have been here all day, that's why.
We are, we just had this one,
No,
not a drop.